Recording in progress.
So I will call us to order the meeting of Thursday, November 21st of the Planning Commission, and please stand for the flag salute. Can we get a roll call of commissioners present, please?
Commissioner Scavdall.
Here.
Commissioner Levy. Commissioner Mulder.
Here.
Commissioner O'Neill. Commissioner West.
Here.
Commissioner Curriasi.
Here.
Commissioner McFarland.
Here.
Thank you.
Thank you. Are there any agenda modifications?
We have no modifications other than the fact that there are two supplementals on the dais tonight related to the use of synthetic netting for that discussion. That is the third item on the agenda.
Okay, thank you. So with that, I will move to public comment on non-agenda items. Is there anyone in the room that wants to speak on non-agenda items? Please make your way to the podium. Seeing no one move to the podium, I will go to Zoom. Is there anyone on Zoom who wants to speak on non-agenda items? Please raise your hand. Not seeing any hands raised, so we will close public comment on non-agenda items and move to the consent agenda, which is review and approval of November 7th, 2024 action summary.
I have a comment. Could we please note that, while it notes I was present, could we please note that I attended by Zoom?
So you're making a motion to approve with the modification that you are attending via Zoom?
Yes.
Okay, can I get a second?
I'll second.
Okay, can we do a voice vote, being as we aren't teleconferencing? Okay, voice vote. All those in favor, please say aye.
Aye.
Anyone opposed? Motion carries. So that moves us on to public hearings. Number one, the Hills LLC and Shadow Light Ranch LLC conditional use permits and special permits. Turn it over to staff.
Thank you, Chair. My name is Cliff Johnson, and I will be representing the Planning Department for this project, which is entitled The Hills and Shadow Light Ranch. To get us oriented, this shows the location of the property. It's just east and above the town of Garberville and just south of Alder Point Road. What you're seeing here is the ranch itself and the two access points, which are highlighted in blue. One access, they're both off of Alder Point Road. One comes off of Wallen Road from the northwest, and one comes off of Little Buck Mountain Road off of Alder Point, and then down and around to the property. The applicant does have an easement for both of those road areas. Wallen Road, it should be noted, is a public road up until about 700 feet or so from the subject property, where it turns into a private road. Some details about the project. This is for 60,940 square feet of existing commercial cannabis cultivation. Most of that is outdoor, and approximately, actually 10,000 square feet of it is mixed light cultivation. There is going to be a 10,080 square foot wholesale nursery that is proposed, so that would be new, as well as a 13,472 square foot processing and operations building that is proposed, along with a just over 5,000 square foot employee housing, which would be on the site. Estimated water use would be 756,900 gallons for irrigation purposes, and that would come from both a groundwater well and rainwater catchment. The applicant is proposing to connect to PG&E and to supplement with solar power. We do have are recommending some conditions to move to solar in the event that PG&E does not get connected to the site, and I'll go into that in a minute. At full build-out, they're estimating 6 full-time employees with up to 11 during peak hours. And again, employee housing would be located on the site for some or most of those employees. Project also includes decommissioning of 3 on-site ponds. One is an older stock pond, and 2 are ponds that were installed more recently with the intent to collect rainwater. Those would be decommissioned. That's as part of a settlement with the Water Board. The project includes wetland restoration related to some of the decommissioning of the ponds, as well as riparian and oak woodland restoration. And there is a number of LSA improvements, culvert replacements, and stream crossing upgrades that would be required and that's for the entirety of the 560-acre property. So the CEQA document that we've prepared does cover those improvements. Some of those are not related to cannabis, but related to the larger property. This is showing the site plan. What you're seeing here is in green the areas of cultivation. There's 4 cultivation sites that would be that are proposed. 3 of those are currently existing, and the one to the north is a former rock pit site. It's referred to as the rock pit site in the staff report and in some of the project details. And that is basically a area that they had removed rock to use for maintenance of the ranch roads. They're proposing to consolidate some of the cultivation areas, including a 5th cultivation site that's not shown on there that has already been remediated, and relocate some of that to that northern area. The other 3 are existing. The green area at the bottom is where the mixed light occurs, and that is also where the proposed nursery would occur. The red circle towards the center is the proposed support facilities and employee housing. And you can see down towards the left-hand side the 3 ponds that would be removed and restored. And then the blue triangle towards the northeast is the location of the well. This is just trying to show those overlaid on the satellite image. So again, the green or yellow are the cultivation areas, orange the support facility, blue being the triangle is the well, the 3 stock ponds to the, or 3 ponds, sorry, down at the bottom there. And then here is the future plans for that support facility, which would include warehousing, processing, and the employee housing. This is a picture of the northernmost existing cultivation area. Here is showing the cultivation area that's towards the center, which is referred to as roadside. And one of the things to note in here is the use of monofilament netting. This is somewhat what we would refer to as maybe more responsible use of monofilament netting, because this is not, plants aren't actually growing into the monofilament netting, and this netting can be removed, and it doesn't require chopping up the netting when the plants are harvested. And then this shows the lower area, which is mixed light and also the proposed nursery. So what you're seeing with the greenhouses is the existing mixed light. Here's a satellite or an aerial image of the 2 ponds, not the stock pond, but the 2 ponds that are proposed to be removed and are required to be removed as per the settlement with the State Water Board. The county did complete an initial study and draft mitigated negative declaration. The applicant has submitted a substantial amount of technical information, which we believe supports the finding that there would be no significant impacts to the environment as mitigated. And so there's a number of mitigation measures that are proposed in that document, including oak woodland restoration, pre-construction surveys that are primarily related to the removal of the ponds, some conditions for that are intended to protect wildlife, such as to contain plastic netting and prohibit rodenticides, to do invasive species removal, at the wetland restoration, to avoid an archaeological site that has been identified on the property, to limit generators. And so that mitigation measure in the document basically requires them to switch to solar power by January 1st, 2026, in the event that none of the PG&E or any PG&E is able to be brought to the site as proposed. And then to limit construction noise. There were no, the only agency comments that were received in response to the circulation of the CEQA document were from the Department of Cannabis Control, and they primarily related to some of their technical requirements and some suggestions that they felt could make the document better. Those are pretty typical comments that we get from DCC, and we don't believe that they changed the analysis of the document. CDFW did provide comments not in relationship to the CEQA document, but in relationship to this project coming to hearing. And primarily they were concerned about the use of the well and its relation to a wetland that you can see here on this satellite image. The wetland's approximately 670 feet from the well, and it is located below the well. Their position is they believe that it does have the potential to be tapping into some of the water that would otherwise be feeding into the wetland. So one of the things that you'll note in the staff report, the applicant did provide some photos showing the wetland, which appears to contain lots of water in it, even at the late end of the dry season. But one of the things that CDFW had asked for is to address their concerns that there be 350,000 gallons of rainwater catchment storage added to the project. And so we have suggested that that's a condition that you impose on the project. That's in the draft conditions of approval. And this is just showing the wetland in question here from a distance. In the staff report, you have some close-ups showing some of the water in it. The well is located just up the hill there, approximately 700 feet away. In response to the notice to adopt the CEQA document, we did get some neighborhood concerns, and so the planning department scheduled a neighborhood meeting in Garberville on October 24th. It was fairly well attended, mostly with residents of Wallen Road. And we talked about their concerns, the main concerns there being the use of the road, Wallen Road, for more heavy traffic, larger vehicles, and also water use and the potential for this project to contribute to drying up of some of the streams that the people, have in the area and have relied on. And so one of the things that came out of that, the applicant did make some commitments, which we have included as conditions of approval, draft conditions of approval, to prohibit the use of heavy equipment or larger trailers on Wallen Road, and that those would then go around the Little Buck Road access. And then also the applicant's committed to the draft condition as CDFW has requested of installing an additional 350, or I should say a total of 350,000 gallons of rainwater catchment, which would be roughly half of the water use that is proposed. We have received public comments separately from that meeting. They primarily relate, again, to road and water use. There's concerns about size, and one thing to note is that this is roughly 60,000 square feet of existing cannabis cultivation on a property that's 560 acres. And it's not uncommon for some of these larger ranch areas in this vicinity. In fact, just to the south, there's some approximately 160 acre ranch properties that each have about an acre of cultivation. So if you consider a little less than 1.5 acres on a 560 acre ranch, it's the department's position that that's not out of scale. And some comments related to the use of the private easement for the transportation of an illegal product. And so that comment references a very recent court case that was decided by the appellate court down out of Santa Barbara County. And one of the things that court case seems to say is that it does refer to the use of a private easement for cannabis being something that the underlying landholders over whose property the easement runs over should be agreeing to the use of transportation of an illegal product over their easement, and if it's not an explicit agreement, that the use of that easement may not necessarily be adequate for the transportation of cannabis. And so what you're seeing here is the two properties that the commenter mentions are opposing the use of the easement over their properties for cannabis. One on the Wallen Road access and one on the Little Buck Mountain Road access. It's the county's position that that court case is not applicable to the situation in Humboldt County. And one of the things that I wanted to bring up, this is from the very last page of that court case, and so the court case was attached to that comment. You should all have it. That they say that the county's land use development code requires that the county must find that the streets and highways are adequate and properly designed to carry the type and quantity of traffic generated by the proposed use. And because of that, they're finding that the county should not be able to find that streets and highways are adequate, and the use permit should not be approved. So that's a different situation than what occurs in Humboldt County. There is no code requirement that requires such a finding. So one of the things that you'll note is that we are often looking at roadways to determine if they're adequate to serve the proposed use. It is related to the finding that the project should not be detrimental to the public health, safety, or welfare. And so for that reason, we often require road evaluations. We often want to see that the traffic that is proposed or occurring on that road is going to be safe and not contribute to public safety or welfare impacts. But there is no specific finding in the code that we have to find that the roads are adequate for the type and quantity generated by the proposed use. And so for that reason, the county's position is that this is not a similar situation and that this is not the case here. It should also be noted that Santa Barbara County, we do understand, is going to be appealing that decision. That's a very recent decision, and so there's more that may happen on that. But again, the county's position is that that is just not the same case here, and so it's not applicable. And so that is the conclusion of my presentation. We are recommending that you adopt the resolution which adopts the mitigated negative declaration and the mitigation monitoring and reporting program, finds that the project does comply with the general plan and zoning ordinance, and approves the permits. And with that, I would be happy to answer any questions.
Are there any clarifying questions for staff?
Let's see, I think I can lean back on this mic. I had a question regarding a CDFW comment back in 2017, I think when the original project was proposed, where they were wondering if there was actually the same scale of existing cultivation prior to 2016. And they were saying that they were only able to find roughly approximately 20,000 square feet. So I'm kind of curious if staff looked into that.
Yeah, so we did, and I can try to pull up the cultivation verification that was done. And I apologize, I wasn't prepared for that comment, but one of the things that was occurring on this property, 560 acres, is that it was spread out through a lot of other areas. And so it wasn't uncommon at the time that CDFW was questioning the cultivation area methods that the county used. So I will look and see if we can find that. I will say, as I'm doing that the county's cultivation verification actually found roughly 65,000 square feet. And so that was more than what they are actually seeking a permit for right now. So give me a second here.
Should we wait to give him more questions while he's searching, though, Commissioner Scavdall?
No, wait.
Okay. Would it be appropriate to ask you a direct question?
Sure, you can ask me a direct question.
Mine's just a general question. Cliff mentioned that the county verifies the amount of cultivation that was previously.
Yep.
Can you explain, since obviously that was done unregulated, can you explain just how that's done?
Absolutely. So back in 2017, we were in a position, some of this is old for some of you commissioners, some of you have not confronted this before. So we were in a position where the state was about to start issuing licenses to cultivate. And we were not going to be able to approve all of the applications that we had. And so in order to allow the existing cultivation community to get state licenses, we adopted a provisional or an interim permit provision within the ordinance. And as part of that, and this was in consultation with CDFW, they wanted each and every one of those, and there was over 1,500 of them, to have the cultivation area verified. So we used aerial imagery from a date before 2016 to go back and identify how much cultivation was existing on the site prior to January 1 of 2016. And that was from a couple different sources that we had available to us at the time. But there are pictures, there are aerial images that will typically have a polygon drawn around the cultivation area with the area of that. And if I talk long enough, Cliff will probably pull that up, and you'll be able to see that.
Commissioner Scabdall, did you want to wait for Cliff, or was your question more direct for the director?
I'll wait for Cliff.
Okay. I guess I would just add on to the cultivation. My history, and just I want you to correct me if I'm wrong, this was presented in like every project for a period of time of maybe 12 months, it seemed like, because there was lots of comments of that area.
As Mr. Johnson mentioned, it was fairly contentious for the first year, 2 years perhaps, of whether or not the cultivation area verification was accurate or not.
Was the cultivation area for the verification for that provisional permit, was that just for folks that applied, or was it kind of done for the whole county?
It was only for people who had applied and had pre-existing cultivation. So we had almost 2,400 permits, over 1,500 of them were for pre-existing. And so we actually did, I think, that 1,550 cultivation area verifications within about a 2 to 3 week period. That was a Herculean task. I will say that, while Cliff's still looking, that we have become far more sophisticated since that time in identifying areas using satellite imagery and being more precise with how we measure it. Some of them, frankly, were a little more generous than others, but we have really refined that.
So if you're still using aerial imagery and stuff, and cut me off as soon as Cliff's ready, do you use that for enforcement, or how does that work?
Absolutely. The aerial imagery has become a key component of everything that we do. So obviously there's the code enforcement element of it, and that was done to address a lot of the illegal cultivation that was going on in the hills. We have also currently use it for the post-approval monitoring, where we go out and inspect on an annual basis. Before we go out, we look at the site to see if anything has changed. And since now we have records and images from the past probably 4 to 5 years, we have a pretty good record of things either remaining very consistent, and then if there's a change, that's the thing we're really going out to look at, to inspect and look at at why something has changed and whether that's in compliance with the permit or whether that's a violation.
Thank you.
Apologize here, I'm finding. I'm not finding it in the electronic records, which would mean it's probably in our,
Paper file.
yeah, in our paper file, which unfortunately is not here. And apologies, I wasn't prepared for that question.
Yep.
Um,
Yeah, I apologize as well. Yeah, and I'm with the additional discussion and that background as well. I'm fine.
I will keep looking, but if there's other questions, I can try to multitask as well.
All right. We had a couple comments come in this week after publication of the staff report, and some of those commenters expressed a concern that they hadn't been notified of the public meeting. So, one, could you just, and I know that happens from time to time in spite of our best efforts, but can you explain what we did to notify the community of the meeting? And then two, are there any comments that came in on those letters that weren't already covered and addressed by others that attended that public meeting?
Yeah, thank you. So we sent notices, there's a number of notices that have been sent recently on this. There was the notice of the intent to adopt the CEQA document, the notice of public meeting that we held in Garberville, and then the notice of this hearing. And those were all sent to the same addresses. And that was everybody within 300 feet of the property, all occupants and property owners, and everybody that has access off of Wallen Road, both occupants and property owners, and everybody that has access off the other drive. And so I did note the one person who had responded and said that they did not receive notice, that we did send that to the address that we have on file for them. So unfortunately, once it leaves our office, we don't know, what happens to it, but the intent there was to invite them as well to that meeting.
No, thank you. And then the second part of the question was, were the comments that they brought up, which were again largely related to Wallen Road and traffic, were those already covered by the people that did attend the public meeting and some of the conditions that we placed on the project?
I believe so. I just wanted to find that specific comment so that I can tell you that for sure. And again, apologies, it's kind of hard to do a number of things on one screen. So that is, it is correct. That comment was primarily about traffic, and what seems to be the recurring neighborhood concern there is the condition of Wallen Road and the heavy equipment that often uses it. And so we believe that that will be addressed by the condition to run all of that heavy equipment and trailer traffic around through Little Buck Mountain Road.
Thank you.
Are there any other clarifying questions? Commissioner Curriasi?
Thank you. One other question regarding, in the environmental document, it had mentioned that there was observation of cultural artifacts on that property, and there was recommendations to mitigate that. And I wanted to just double confirm that there were mitigations. I think one of them was to ensure that there was no road development within a certain distance of that, and there was no disturbance of that area.
Thank you. That is correct. The recommendations were to avoid the disturbance of the cultural site, which there is unfortunately an existing ranch road that runs through that. And so I think their recommendations were to avoid using that. We felt that it would be more appropriate in the CEQA document to actually require that they retire that access completely so that there's no ability to, have it as an attractive nuisance to drive through. So that is one of the mitigation measures, is that they would actually retire that, that portion of the ranch road completely.
Thank you.
Any other questions? Hi, Cliff, I have just one clarifying, or a couple little clarifyings. What I heard from you, neighboring properties that are at the 160 acre partial size have 1 acre in cultivation, and this site could be potentially 3 partials, which could be up to 3 acres if it was dropped down into 160s. Is that mental math kind of correct or in the right ballpark?
That's correct. I think along those same lines, there is the large parcel provisions of the cannabis ordinance, and there haven't been too many that have taken advantage of that. But if the zoning is correct, and this zoning is agriculture exclusive, which would allow for this provision to be taken advantage of, new cultivation of up to 1 acre for each 100 acre increment of a property that's over 3 acres in size could be permitted. And so, in theory, they could pursue new cultivation for up to 5 acres on the property.
Okay, I kind of, thank you for going there. That's kind of what I was trying to capture when I read the comments of scale and then look at the size of the partial. I was just trying to capture that this is, proposed project is 1.5 acres, and with the ordinance could potentially be up to 5 acres. So that was it. Commissioner West?
I have a question about the violations that are being resolved with the water board in the cannabis cultivation policy. Can you talk about, so like, looks like the condition of approval number 6 talks about like that the applicant needs to be to adhere to and implement the requirements contained in the water board's cannabis cultivation policy. How does that interrelate with like resolving the ongoing violations from the water board? Does the applicant, what I'm getting at is we've heard some public comment around the concern of past violations and remediating those concerns. So does the applicant need to fully resolve the issues with the water board before they can fulfill this condition? Is that making sense? That was a long-winded question.
Yeah, I think it is. I mean, the intent with that condition is that the current site management plan, there has been a lot of discussion and negotiations, let's say, about what needs to happen with the restoration of the ponds. And so what this condition was getting at is that the most recent agreements with the water board and the applicant are not currently in their site management plan. And so this would require them to update it to show that. One of the important things about this project and is that it's not just the cannabis permitting. The CEQA document would permit the restoration work that they're compelled to do by the state agreement as well. So really the project includes the restoration and the removal of those ponds. So there isn't necessarily a condition that says you have to do that. That's part of the project.
That makes sense. Thank you.
Everyone good with their clarifications? Okay, so now at this time, I'll invite the applicant up to the podium to speak. You have up to 15 minutes to present, and then you all also are afforded up to 5 minutes after public comment if you want to clarify anything that has been stated. So public comment on this has been opened, and we're starting with the applicant. Once the applicant's set, can you please put 15 minutes? Oh, you already
I
got it
asked
there.
earlier if I could sit here, is that okay?
That's accommodations. I would say that's accommodations for someone that's, you can present there or there, I believe.
Okay. So, I'll wait till afterward to address any concerns that come from the outer world or whatever. You guys can ask me anything you want. I'm well prepared here today. I can address some of these questions. Yeah, actually, he did that already with the 6 acres or whatever. You can kind of, so I'm growing way less than is allowable on that. What was your, those mitigations are already in play. There's an enormous amount of work that they're aware of, and then some that's already been done that they aren't aware of. We've been in negotiations with the water board for, what is this, 6 years, 8 years now. Enormous amount of work has gone into this. They are supportive. There is no longer ponds there. They are gone. That is mitigated. There is some wetland restoration program that has to happen in the next 2 years. Other than that, it is solved. It is resolved, and there's a few culverts that have to go in as well, but pretty much 90% of it is taken care of, and 100% of it is negotiated and done. So there's no more need to hash out anything between the agencies and myself. I feel like we're getting along now, and things should be moving forward smoothly. What was your question? You had one.
So you probably want to present all the way and then have clarifying questions at the
Okay.
end is the best way to do it.
Sounds good. I guess I would just say before the comments, the water issue. There was an interesting study, or actually I'll start with the concern from the water board, which was that the wetland area below my well would be adversely affected in any way. There's gushing water out of that. That is what the town used to call pipeline. It used to feed Garberville, so there's an enormous amount of water there. That's why I purchased the property, is there's an enormous amount of water on that property. There's 6 springs I do not use. I do not use that spring as well, other than for fire suppression or emergency agricultural stuff that has nothing to do with cannabis. The USGS came out with a study where 34% of precipitation goes into the groundwater, and between that well and that site, that equates in a drought year to over 22 million gallons of water. The ranch as a whole on a drought year is about 800 million gallons. So on a big year, it's about 800 million gallons of water that ranch sequesters. And so from my stance, we kind of are acting like 500,000 to me would be like taking a glass of water out of a pond or something. So there's an enormous amount of water there. It's not an issue. I take great pride in taking as many measures as I can to have rainwater catchment and to be conscious of the use of water. I am a 5th generation almond farmer, and 40 acres that I inherited down there uses 1 million gallons a day. So I know an enormous amount of water in California, and so cannabis in this context on this ranch uses minimal water from my standpoint. The road issues, prior to this hearing, we were going to come here before, and people had had their concerns. I did a massive study during that time, and in that time found out there was 45 parcels on that road, over 50 if you count the surrounding ranches, and at the time 75% of those were growing themselves, so I don't think that they would have an opposition to cannabis necessarily. Whether they had a permit or not is up to you guys to look into if you wanted to, but that's about 150 to 160 cars because there's multiple houses, multiple programs. There's 5 cannabis companies on that road. There's 4 heavy equipment operator companies. So there, from my stance, there was just a misunderstanding and a mischaracterization of the use of that road. The biggest comments were the quality of the road itself, which is a county-maintained road, it has nothing to do with me. And the quantity of traffic on that road, they just didn't know. And during that public meeting that we had, I point blank asked everyone, do any of you know which cars are associated with my project or not? And not one person could say it. So basically, they were unaware of what the truth was about who was doing what and when. And so I had already implemented the program to send heavy equipment, delivery trucks, whatever it may be, around the back road. So the traffic that they're talking about is not me. It's an accumulation of 45 different parcels, 5 cannabis companies, 4 heavy equipment operator companies. So I think what I understood after that meeting is that most of the people went, oh, okay, we understand now. So information got to the right people, and hopefully they got their concerns met. I still follow those protocols. I'm very cognizant. I painstakingly go through a lot of effort to take care of my ranch, my neighbors. I am a businessman in town. I take a lot of pride in my aesthetic and my efficiencies, and I do what needs to be done. It's not easy to go through this process. It's been a long time, and I think I've jumped through all the hoops and do very well at that. So depending on what happens with comments on the thing, I have a lot more to say about that if you guys have concerns about some of the questions people ask. But I run a very tight ship. We follow all the protocols way and beyond. So we just had our inspection, just got our inspection report, which I brought, I believe, passed with flying colors. We had our hazmat inspection 2 weeks ago, passed with flying colors. In fact, they said we're a model farm that they would like to use as an example. Again, I'm very aesthetically oriented and take a lot of pride in what I do. So it's been a long time in coming. I'm looking forward to having this permit. So I'm here for any questions you have, and we'll go to public comment, I guess.
Are there any clarifying questions from the commissioner or questions of the applicant?
Just a brief one in light of previous permits. It's kind of a hot topic now. Do you have a fire plan in place?
Yes, I do. Not only do we have a fire plan, but we have our own firefighting equipment. And all of our employees are OSHA certified. And during that OSHA certification, we go through the fire protocols. So we're above and beyond out there, for sure. And I know a lot of the local firemen, of course, but the CAL FIRE is 2 miles from us.
Okay, so now we will go to public comment in person. Anybody who wants to speak on this project in person, please make your way to the podium. You'll have up to 3 minutes.
I wanted to say that his discussion of the ruling was not the best. He focused on the land use and development clause. The main thing is California Business and Professional Code 26051.5, and that requires the applicant to get written consent from landowners. And the appellate court expanded or said that the ruling encompasses landowners with easements. So they need to give consent. Isn't that right? 26051? Doesn't it say that?
We don't question staff.
Okay.
We make comments to the commission.
All right. Well, it does. So not only does it require the consent of the property owner that the farm is going to be on, but it needs consent of everyone who has an easement that the farm has to go through. He's right, they're appealing it, but it hasn't been stayed by the court, so in effect, it's law. So I would ask, does he have in the file all the consents of these property owners?
Thank you for your comments. Is there anyone else in person? Before we go to Zoom, I do want to add that I just want to clarify that when anyone's making public comment, you're talking to the commission. You aren't interrogating staff. You're respecting staff. So let's please be mindful of that. You can make all the comments you want, but be respectful of staff, at least while I'm chair. Zoom, please raise your hand. Two, 530.
Hello. I'm listening in. This is directed to the Planning Commission. I noticed you had some documents, or this is documents that address the objections from landowners where the easements were used for the transportation of cannabis. I listened to Mr. Sweet talk. He addressed the road issues, but did not advise the Planning Commission that anyone provided him with written consent to use their easements for the purpose of accessing the farm or transporting cannabis. I believe that the reading by Mr. Johnson, and this is directed to you, is incorrect as to the court's ruling in J.J. Crandall. It specifically addressed the California Business and Profession Code, stating that the cannabis applicant, that would be Mr. Sweet, must provide evidence of the legal right to occupy, use the proposed location, and provide a statement from landowners of real property, the court, so that he could conduct commercial cannabis activity. The court said this also included owners of easements. The MND does not provide proof that Mr. Sweet provided the Planning Commission with written consent from any landowner. And you know that this application applies because you require it on the level of landlord and owner, which he did supply his written permission to lease from the leasing to conduct cannabis activity. Do you have any questions?
Is that all of your comments? Just in public comment,
Well, I'm just wondering, I'm wondering if the Planning Commission understands the law, that you are required before you cannot approve a conditional use permit for cannabis, particularly to transport cannabis, because by approving this permit without consent, you are forcing the landowners to commit to violate a federal law. And in that case, the court clearly says that cannabis is illegal under federal law, regardless what California wants to believe. So if you approve this, you are actually forcing people that are objecting to it, and I know you have objections from the landowners of those easements that are designated in the Planning Department's mitigating negative draft. You are aware of those objections. You are aware of them. So the question is the Planning Commission going to break the law? This is the law of the land right now of California. And in the supremacy clause, that's all that counts. Federal law
30 seconds.
preempts state law. That's all I have to say, and I hope you guys follow the law, because I think you're going to end up causing the taxpayers a tremendous amount of money when all these lawsuits come down.
Thank you for your comments. 2530.
thank you. I guess I would like to highlight those last comments. The county's position on the easement is clearly at odds with the decision made by the appellate court. The important thing, I think, that was said at the very end of the last speaker was the supremacy clause. It doesn't really matter what ordinance or any other doctrine or document that the county has talking about easements, it cannot trump the federal law. So the federal law is going to persist here whether we like it or not. And the county, through its permitting process and through the decisions made by the Planning Commission, simply cannot try to trump federal law. And I think if the commission chooses to thumb its nose at the at this decision, it's going to be on record, and it's going to come back to bite the county later on through perhaps class action suits or whatever. And I don't think the taxpayers really want to be putting up more money to fight legal situations that could have been averted by simple planning commission decisions. Say, hey, look, this isn't right. We need to get permission from the owners before we can proceed. So let's do the thing that's right and keep us out of legal trouble. Thank you.
Thank you for your comments. Is there anyone else wishing to speak? Please raise your hand. Seeing no other hands, I will come back to the room. And one other thing before we go to the applicant, I wanted to clarify. The department did offer people the ability to submit written comments that would be read into the record if they felt unsafe to travel to this hearing. Is that correct or incorrect?
In response to the email we received, yes.
Okay, I just thank you for that. So now at this time, we'll go to the applicant. Up to 5 minutes to respond to any comments, anything you heard during public comment testimony that you would like to clarify.
I'm not an attorney, and this is so new. I have no comments in regards to this new legal interpretation of the law. It sounds really confusing and complex, so we'll see what happens with that. I guess after that, I'll just say a few things that I was going to say before. Thank you for the opportunity to address you this evening with any concerns. It's been a long road. And I have, it's been 8 years and more money than I have in an attempt to build a professional, conscious cannabis company for myself, my family, and my community. I have been subject to an enormous amount of scrutiny and oversight. And through all of it, I have met every requirement, stipulation, request, study, overview, analysis, and on that has been asked of me, whether it was warranted, reasonable, logical, or fair. Although I do respect the concerns of specific people or entities, my hope is that we are here today to speak of substance, factual data, confirmed evidence, and personal knowledge, and avoid conjecture, assumptions, accusations, or false claims. I have studied the history, the data, the impacts, the cause and effects. We have done cost-benefit analysis, researched the social and political realities and causation, built models, and have created an eco-friendly, socially aware, net positive company. And we appreciate the opportunity to try to stay alive in these extremely difficult economic times. Again, I am very particular, aesthetically driven, environmentally aware, and am motivated by the overall sense of community welfare. If there are elements of opposition, then I ask that we look at the substance of that opposition and whether it is warranted on the basis of reality, or whether the intent is just to be against me, or the project out of emotion or unsubstantiated claims, whether that be a neighbor or an agency. I guess in terms of the federal law, I don't feel like I should be the person to deserve this scrutiny over this issue. I don't necessarily feel like I want to be the poster child for that one. In regards to the compliance, you asked about fire. So we're OSHA compliant, all of my people, not just one of them. We're Ag Department certified with the pesticide applicator. We had the hazmat that I referenced, fire safe that I referenced. We do tailgate meetings and educate and build teamwork on how to be safer and more efficient across the board. We have emergency heat and illness prevention programs, emergency response and safety measures. We implement water quality and usage checks and monitoring protocols. We follow all the requirements by the multitude of water agencies and file those reports. And I'll say this, we've been held to a much higher stringent than the average, and we still go above and beyond. We have everything that you can think of: equipment checks, maintenance logs, incident reports, oversight reviews, et cetera, et cetera. The point is, I'm aware, willing, and capable to operate legally and compliantly. I have been forced to do massive research and studies and have that data, the facts, and the evidence. I think the county supports this, as does the relevant evidence and agencies, even the ones that I've had conflict with. We've resolved those issues and any concerns as I have a right to do so. There will always be the ill-informed naysayers and those who are motivated by their selfish desires and inability to understand the complexities of what others endure. So I thank you for your time today. I thank the county for doing an enormous amount of work and working with me closely to get to here today. All my consultants, all my lawyers, thank you guys, and I hope it moves on. Thank you.
Thank you. Are there any clarifying questions for the applicant? Nope. Okay, we'll bring it back to the, close public comment, bring it back to the commission. I have a clarifying.
Yeah, before we do, we've got a couple things. First, I'd like Joel Campbell-Blair to respond a little bit to the legality of the easement, and then Cliff does have the cultivation area verification.
Yeah.
Hi, folks. Everybody hear me?
Yes.
Okay. The case is brand new. We're not sure what it all means, and in the case law method, we really won't until other courts consider it, decide to extend it or limit it, apply it in new circumstances. As Cliff said earlier, Santa Barbara has a provision in its county code, and so its issuance of the use permit was challenged based on that finding. Since that's the only thing that's before the court, that's the only thing the court really ruled on as a matter of law. It referenced the business professions code, but that wasn't really before the court because that is a mandate for the state. When the state issues permits, it doesn't apply to us. And therefore it's dicta. It doesn't have the force of law. The state has not stopped issuing permits. They don't feel like that applies to them either. And we'll kind of see where it goes. I'm happy to answer or try to answer any questions about it people may have. But I would just maybe warn or caution everybody not to over apply the case. You know, when judges make law, they make law only as to the issue that was right before them. And that was a Santa Barbara County Code provision.
Do any commissioners have a direct question for county council? Commissioner McFarland?
I'm just wondering if you can clarify. You said that the business code only applies to the state, so it's dicta. However, the state is not applying it. So I guess I'm confused because it sounded like you said it applies to the state, but the state's not using it.
Yeah, so the state law, the law says, you know, the state shall not issue a permit unless these things is a long list. But because that wasn't before the court in the Jay Crandall case, whatever opinion the court expressed about it doesn't have the force of law because that wasn't a state permit being reviewed. So even though the court talks about it, it's just dicta. It doesn't really have the force of law. Now, if you know, if a permit was issued by the state that was challenged, then, you know, a court might then look at that opinion and look at its reasoning and decide whether they think it's convincing. But it in itself does not have binding force of law. Does that make sense?
Yeah, so the state is basically allowed to choose not to abide by it until it's challenged in a court case.
Basically, yeah.
And theoretically, the county could hold the same stance.
Yeah, well, the county, as Cliff said, we don't have that specific finding. If we had to make a finding under our county code that the easement was adequate for the purpose, then we would look at that opinion and say, well, that's pretty on point, we should follow it. But we have actually more specific findings, you know, that is a Category 4 road that talks about kind of the physical capacity of the road without the kind of qualitative finding of adequacy. So you just don't have to make that finding.
Thank you.
Commissioner Scavdall?
And, I mean, we have a lot of projects that are utilizing private roads, and that applicants may or may not have easements. There are different types of easements, as I understand. It could be a prescriptive easement, a deeded easement, with different conditions. Those issues I thought were typically between, you know, the property owners, those granting the easements and those benefiting from the easements. Is the only reason in the Santa Barbara case that the county is in fact somehow tied in is because of this stipulation or this code that you said were there to verify the adequacy of the road? Is that the only thing that's bringing them in? Because otherwise it would seem like it's a matter between the applicant and the property owners.
Yeah, that's the way we read it. And we would think of this kind of like maybe the way Forest Service roads are, where we don't have the authority to give somebody permission to drive across somebody else's property.
Right.
We look at whether the road can handle it, but we don't have the ability to say yes or no. They've shown us that they have an easement. We don't need to dig into the scope of the easement and all those things, just like we wouldn't dig into whether a Forest Service road is, you know, available for cannabis transportation. Those are things that the permittee kind of does at their own risk. And a lawsuit between them and the property owner could happen, but I don't really see a big exposure for the county here.
Is somewhat, in my view, similar to the right to haul timber on a private road. Whatever, the condition of the easement and it's between one property owner and the other. Okay, so thank you, you've answered my question.
Are there any other clarifying questions? Okay, thank you, County Council. Now we're going to go to Cliff, who is going to pull up the CAV, I believe, and show that so that way we can see that.
Okay, so bear with me, and it should be coming up. Again, because it's a 560-acre ranch consists of 3 legal parcels, there was actually 3 applications originally submitted, so the cultivation area verification is actually in 3 separate project files. So this right here is for one of the 3, and this is actually the cultivation areas that would be and have been remediated and would be relocated up to what's referred to as the rock pit area. Let's see if I can. And so, I don't know if you can read that there, but basically we're saying approximately 5,989 square feet. And that image is from May 2014. Let's see. This is another one, which is showing 3 cultivation areas that are outdoor. And if you can read that note at the top left, which you probably can't. Yep, 22,937 square feet. And then this one here is showing, there's, if I scroll down, there's 4 areas. And we are saying 25,731 square feet. So that is the bulk of what was used for the cultivation area verification. Again, we also have said it's really more of an art than a science, trying to figure out what really happened with all these old aerial images and trying to scale them and that sort of thing. But what we had believed was that there was roughly 65.
Thank you for that. Are there any other questions in regards to that? Okay. I wanted to make a clarifying question in regards to access of partials. I do recall that there's some projects out there we've approved that use Forest Service roads, and there's a direct comment from Forest Service, if memory serves, that says it's federally illegal and they don't support it. And if I remember correctly, we just had the applicant sign something that said they're aware that it's federally illegal to drive across that highway or something along those lines. I can't remember. This isn't the first time federal illegality has been referenced in regards to accessing a project. Is that correct?
That is correct. In fact, the county early on adopted kind of a policy statement that we were not approving the use of the road, and that the property owner was essentially taking the risk for transporting over a road, where if they didn't have the right to transport over that, that was their risk.
Thank you. Commissioner Curriasi?
That's kind of where I was settling as well, just sort of reiterating that we're not approving transport of cannabis, we're approving production, since we don't have this local code.
Okay.
Yeah.
Comments, concerns, Commissioner?
For a different topic, but not until we're done with the roads.
Just real quickly, while we're on the topic of roads, I just wanted to acknowledge that, like, I hear the public concerns, but I too am not a lawyer, and so, like, I have to I depend on county council to provide their legal opinion and on this matter, and they are the expert in the situation for me, and so I will be depending on them for their legal interpretation.
Okay. At this time is not when applicants speak back, only if there's a direct question. So I think we've covered roads a little bit. Commissioner McFarland?
Okay, so I first just wanted to acknowledge and thank staff for the groundwater section in the report. I found this a really helpful addition to these reports. It actually quelled a lot of my questions, so I only have one question for you tonight, rather than the usual 10. So, and I appreciate you walking through the numbers in that, and I understand, 350,000 gallons is a very small amount, and the rainwater catchment will reduce the pull on the well by 40%. So there is a section where it talks about the county limits the number of permits based on planning watershed. And so my question is, and I know they limit the number of acres, do we put a cap on the amount of water that's pulled for planning watersheds? And as a second to that is, when we're considering a permit like this, recognizing this is such a small amount, do we consider the surrounding wells and their pull on the same wetland?
So those are great questions. The county, there is no cap on water use. One of the things that we try to look at, and one of the things you'll note in this project, is there is a assessment prepared by a geologist. And so often when you have that assessment, they are looking to try to identify whether there would potentially be impacts on adjacent wells or water sources. That's not always something that you're going to see in the project file. There is one here. There is a provision in the Canada's cannabis ordinance, the second one that was adopted to sort of try to deal with some of this issue. And basically, what it says is that if you're on a smaller parcel, I believe it's 40 acres or smaller, and your well is within a certain distance from the property, you do need to do well testing, drawdown testing to see whether there is some connection between that well and any adjacent well. So that's not a standard here for this project for two reasons. This falls under the first ordinance, and this is not on a small parcel, it's on a much larger parcel. So that said, we do sort of consider it to a certain extent, and that would really relate back to the public health, safety, and welfare. So if there's a reason to believe that it might be impacting adjacent wells, that is something that could be considered, but there is no specific standard in place.
Are there any, so broad question to either director or yourself, are there any plans for the county to pursue looking into that so that we don't end up in like a Merced type situation?
So that was part of the reason to limit the number of permits by watershed, is to make sure that there was a cap there to protect the overall integrity of the watershed. That's why in either impacted or refuge watersheds, we don't allow any new permits to be applied for.
That's, okay, so that makes sense, that's great, but there's no future additional plans to pursue this further?
Well, we had wanted to undertake a study, to understand more thoroughly carrying capacity of watersheds. And we, unfortunately, the funding we had for that fell through. But it's extremely difficult because watersheds are different depending upon their size, depending upon the slope, depending on the geology. And so it's not really one size fits all. In Humboldt County, we have a real challenge on that front. We do try to look at things where there are springs, and the geologists that wrote this report typically will include in their reports whether or not there's likely to be a spring, whether or not there's adjacent wells in the area, and following through with the governor's order on that to make sure that it's not adversely affecting either springs or wells. That's typically a part of the report.
Thank you. If I find some planning money, I'll let you know.
Okay. Commissioner Scavino?
Is the resolution number equal the same as the file number? So when you say resolution 24, it's 1591 in this case? No. How do you know what, sometimes people know what the next resolution number is, and I don't.
Next one adopted.
Next one adopted?
Yep.
Thanks. We heard that. I'll make a motion that we adopt the next resolution, which does the following: adopts the mitigated negative deck prepared for the project, adopts the mitigation monitoring and reporting program prepared for the project, finds that the proposed project complies with the general plan and zoning ordinance, and approves the conditional use permits, special permits, subject to the recommended conditions of approval.
Can I get a second? And then I think there's some discussion.
Yep, I can second. I would like to amend, suggest a couple of amendments. One is just a couple corrections to the resolution. One is item 4C references, makes the has the incorrect name for the mitigation measures in the MND. So I'd like the correct references in there. It's related to the mitigation measures around the indigenous artifacts. And then 2 would be correcting Resolution 9C, which incorrectly states that there's no indigenous artifacts within 600 feet of the project. And so that needs to be corrected. I think, although it looks like...
Yeah, could I just clarify that that could be a correction. Technically, though, the cultural site is not within 600 feet of any of the cannabis proposed actions or cultivation or any infrastructure. So it is on the property, however. And there is that former ranch road, and we do have a mitigation measure, so perhaps that should, maybe that should still be corrected. But I did want to clarify that.
Okay, thank you. That makes sense to me. So would you accept those amendments?
I would accept those amendments and appreciate your detailed review. So thank you.
Thanks.
Any other discussion or comments? Being as it's a larger project, I'll do a roll call just so that way if anybody wants to, oppose or speak whatever, they feel a voice vote on a larger project wouldn't be fair to all the commissioners.
Commissioner McFarland,
Yes.
Commissioner West,
Yes.
Commissioner Curriasi,
Yes.
Commissioner Mulder,
Yes.
Commissioner Scavdall.
Yes.
Motion carries.
Project is approved. We're gonna go on, you want a 5-minute or 10-minute recess before we go to the next project? 5-minute recess.
Progress.
Okay, I'm gonna call us back to order and bring us to the next public hearing, which is the Laura Muzi conditional use permit modification. And I'll turn that over to staff. I'll open the hearing and turn it over to staff.
Excellent. Hello, we're pulling up the presentation really quick. My name is Colin Slavey. I was the assigned planner for a modification to PLN 12468. The applicant is Laura Muzzy. Excellent. Okay. So the project location is in the Bridgeville area on the south side of Highway 36. The parcel is 269.5 acres. This is the current premises site plan. 30,000 square feet of pre-existing outdoor cannabis cultivation and 3,000 square feet of ancillary propagation are approved on the parcel. The project description for the original project included a water source, which was cited as a 345,000 gallon rain catchment pond, and an additional 70,000 rain catchment pond, which was proposed and has not yet been developed. The modification involves adding a well as an additional water source and increasing the amount of water used annually from 200,000 gallons to 759,480 gallons. The details of the well. It's likely to be hydrologically disconnected as it is not yet drilled. We can't say for certain, but David Lindbergh prepared a hydrologic connectivity study and made the finding or the assumption that if it were drilled, it would be hydrologically disconnected. The well's outside of SMA buffer areas, streamside management area, buffer areas. The proposed use is up to 486,000 gallons of water. The applicant explained they'd pump an hour 9 times a day and expect to achieve the volume in 180 days. This project is not conditioned to forbear during the dry season, and the well may be used, as it's written, as either a primary or a secondary water source. The well is located down here. The existing and approved water sources. As I mentioned at the beginning, the approved existing rain catchment pond was described as 345,000 gallons. Through this process, the applicant explained that recalculating it, it's actually a 514,000 gallon rain catchment pond. The original entitlement for irrigation water from that pond was 200,000 gallons. Again, there was a proposed 70,000 gallon pond, and there's a to-be decommissioned well, which was not ever used for irrigation, rather residential. This is the difference in the footprint of the pond from 2016 to today, pretty much the same. The same. The second part of the modification involves the increase in the amount of water used for cannabis irrigation from 200,000 gallons to 759,000 gallons. The permitted volume is approximately 6 gallons per square foot. The proposed volume is 23 gallons per square foot, which is a significant increase. The purpose of the increase as described, sorry for all of the words on the presentation, but was increasing the amount of water irrigating. The cannabis plants will produce larger cannabis buds, which are more marketable, and the current use makes buds not big enough for the market. The other explanation was that a well would be a more reliable backup water source in the case that there was a drought and the pond didn't fill to the necessary volume to support the project. And finally, the applicant would rather have an entitlement to more water and use less than was permitted than use more than what they were allowed to and be non-compliant. So my staff recommendation is written, 1, to either adopt the resolution as it's written, which does the following: finds the Planning Commission has considered the MND, finds the proposed project complies with the general plan and zoning ordinance, and approve the conditional use permit modification, subject to the recommended conditions of approval. The alternative to the recommendation would be to either add or delete conditions of approval, deny the project, or modify the project such that, acknowledging that a typical cultivation site uses closer to 15 gallons per square foot, and the existing and proposed rainwater catchment reservoirs could provide all of the annual irrigation needs, amend it such that the entitlement requested is reduced to approximately 495,000 gallons per year. We concluded that the findings, as they were made, may be considered, how do I say this correctly? The Planning Commission may consider that the request for an increased entitlement is excessive or larger than may be necessary based on your judgment, and impose a condition limiting the irrigation to a more reasonable or standard amount. I did leave out one part of my commentary regarding the groundwater recharge rate of a parcel of this size. Again, this is a 265 acre parcel. Excuse me, a 269 acre parcel. And when we did an analysis of groundwater recharge in Humboldt County, we calculated how much water per acre our soil can suck up, and that is approximately, in an average precipitation or year of precipitation, which is 57.7 inches per year, 530,000 gallons of water per acre. Even in a drought year, where as little as a third of the average rainfall is recorded, at least 175,000 gallons of water is recharged per acre of the ground area. And considering the size of the parcel, as much as 47 million gallons of groundwater recharge could be expected in a year. So that's something to consider in light of the discussion. That would be the conclusion of my presentation.
Thank you. Are there any questions or clarifications for staff? Seeing none, I will open public comment and offer the applicant. Is the applicant present in the room? You can make your way to the podium, and you have up to 15 minutes to present.
Sweet. Well, thank you for presenting, Colin. And I just want to really briefly make the point that we're not necessarily going to use all of the water that we're requesting permission to use every single year. It would allow us to store more water for in case of fire or if there's severe drought years. But honestly, it hasn't been planted while I was the applicant ever. And yeah, I just want to make the point that we're not necessarily going to use all the water that we are applying for. And yeah, thank you very much. better safe than sorry on having more water than not enough. Yeah. Thank you.
Is that everything?
Yeah, that's.
Okay, so we got a question from a commissioner here.
Yeah, so as I understand it, you haven't actually put the well in yet?
No.
Okay, and I kind of backed into how much water you need to get out of the well. It looks like you're looking for a well to produce at least 5 gallons a minute in order to meet your projected quantities that you're going to pump out of the well. And I don't have any particular concern with you having, in fact, I like that you have rainwater catchment and you're proposing to have a well backup. Little concerned about the kind of quantity of water that you're proposing, which is sort of, these are my words, like how much water you need. Well, we want this much because we can. I guess my question is, do you have any sort of water conservation plans? I'm more concerned about wasting the commodity, overuse, over irrigation.
Yeah, I mean, that's.
Hoses just running rampant or sprinklers left on all day or whatever. It's like, how do you manage that?
Oh, that won't be happening on my watch. In my experience with like employees and stuff, it's harder to get them to water the plants enough. Like I'm more likely to come up on like wilting plants that haven't, they would really like a little bit more water. And I feel like this application is our request for increased storage is sort of, could be part of the water conservation plan because we're increasing our storage and it doesn't necessarily imply increased usage.
How do you actually irrigate? Are you on drip irrigation or
Well,
sprinklers
there
or
hasn't been
hand watered or?
a combination in my, it's not set up yet. It's still, it got bulldozed, that there were people out there, all the plastic's been cut. It hasn't been in operation as far as I've seen. It's still, there's a lot of work to do. I've been out there just like cleaning stuff up. There's the previous permit holder did some kind of wacky stuff. So we're still in the process of remediating everything and getting it up to speed for operation. But I've, usually some combination of drip, feeding typically is by hand, and definitely trying to reduce runoff because that's just a loss for us at the end of the day.
Thank you.
Thank you.
What I heard you say is you've taken over this project and you actually haven't cultivated yet. Is that correct?
That's correct.
Okay. So what I'm hearing you, and correct me if I'm wrong, is by you asking for this increased entitlement is you're under the belief with your cultivation practices that 6 gallons a square foot is not enough water to cultivate what you're trying to cultivate, and that's why you're asking for the water increase. Is that correct or incorrect?
I would say I don't know exactly what is required. I haven't personally, because I haven't cultivated there yet, I don't know exactly what's required. I've been told that, we're requesting permission to potentially use more, but it doesn't imply that we're going to, I would have to review some numbers to give you a precise estimate of what would be required for the season. We're working on shortening our seasons and other measures to reduce water usage as well.
Okay. I'll pause right there. No other questions? Okay, so I'm gonna, at this time, go to public comment of anyone else in the room, and then you will have up to 5 minutes at the end to do any rebuttals or anything like that. Is there anyone else in the room that would like to make comment? Seeing no one coming to the podium, is there anyone on Zoom that would like to make comment? Please raise your hand. Seeing no one on Zoom raising their hand, I will bring it back to in person. Is there anything you would like to add to your presentation?
No, I think everything's been said that I can think of.
Okay, thank you.
Thank you.
I will close public comment now and bring it back to the commission. Is there anything staff would like to clarify or feel, I mean, Director, you're looking at me like there's something you want to say.
Yeah, I sense the kind of the tension with just approving this outright, and perhaps there is a hybrid recommendation, as was mentioned by staff, that would allow a certain amount of water by right, but allow the full amount of water to be there between the pond and the well, but not have that be a total water allocation on an annual basis. Maybe part of the question would be to try to figure out from the applicant if there is a water budget that they'd feel comfortable with. Normally, around 10 gallons per square foot is a rule of thumb. It could be 15 gallons per square foot, but obviously getting to 700 gallons for a 30,000 square foot cultivation is over 20 gallons per square foot.
So for me, memory, there's only a couple that have been over 18 gallons a square foot over my time of following the commission. I think one was at 20-something in the Mattole Valley somewhere, if I remember right. And that was my line with questioning. So I guess that I'm going to use the director's guidance here. Ask the applicant to please come to the podium. And what we're trying to find out is there a direct water budget? And that was the reasoning I was trying to ask you the question of, in your past practices, do you believe 6 gallons a square foot is not enough water?
I'm so sorry. I have to ask. When you say 6 gallons?
6 gallons a square foot per for a whole year.
For a whole year, 6 gallons sounds not adequate. Like, in my personal experience, I would say, like, at the peak season, hottest days, you're going to be 1 gallon per square foot per day. Like, at that, for a couple weeks a year, at the hottest times, and it just varies depending on the weather. I would definitely have to do some math.
So is there a realistic water budget that you believe would be adequate to suit your needs for the cultivation that is closer to the 10 to 15 gallon a square foot range per year? So somewhere, I think staff is, what I've heard staff present is the findings above 15 gallons a square foot may be more challenging for them to find. Do you feel that you could operate this site closer to 15 gallons a square foot?
I would be open to looking into that for sure. I mean, if we could do 18 or whatever whatever would be available. Of course, it would be better to have more than less just in case anything happens, but of course, we'll take what we can get.
So would you be okay closer to that 15 gallons a square foot, but being allowed to have that storage? I think it was 500 and something thousand.
Totally. I mean, that sounds good by me. If we can store it and agree to use 15 less than that full amount, that would be great.
Okay. Are there any other direct questions for the applicant?
Yes.
Commissioner Scavdall?
Will you prioritize, will you use the rainwater catchment pond first?
Sorry, I missed.
So you have a rainwater catchment pond and you're proposing to have a well.
Mm-hmm.
Are you proposing to use the rainwater catchment first and then supplement with well water as needed?
I imagine that would be just because the well might not run year round or something. Since we haven't drilled it, we don't really know, but I would assume prioritizing using the rainwater catchment first.
That would help me, right? And then and it sounds like we're going to meter, but maybe also you're proposing a cap or a reduced amount. But I would be okay with prioritizing rainwater catchment first, supplemented by the well.
Okay. So if we get any more questions, we'll call you back up.
All right.
And we're just trying to find a solution here. Mr. Curriasi?
Actually just went back to our last agenda 2 weeks ago, and the Macross project actually, if I calculated it correctly, came out to over 27 gallons per square foot. So I think I'm and I haven't really seen a specific item in projects presented to us that's addressing a sort of a water density or a water intensity use per square foot. So I'm a little bit uncomfortable using this particular project to kind of come up with something up here on the podium. I'd be more interested in seeing a sort of a more well thought out argument from staff about what a reasonable target would be.
Good catch, because that adds another one over 20 that I didn't even realize, because sometimes it doesn't, you have to do the math where some of them it says exactly how many gallons per square foot. Do you have something, Director?
Yeah,
I
don't think it was 20.
So the one thing with that project, the Macris, if you recall, they had asked, they had actually revised their water use down, and so what ended up getting approved was much less. And they had said they were going to grow, smaller plants and shorten the season. So I think their original budget may have been that much. I don't recall exactly what it was. I want to say it was like 500-some thousand gallons. But what ended up getting approved was much less. I think it was closer to 200,000 gallons, if I recall. So just wanted to clarify that.
Okay. Yeah, I think I went off the staff report, the numbers in the staff report. So I think, thank you for the clarification. I think, so it sounds like staff is doing a gut check when they're at the gallons per square foot.
Yeah, I think that's fair. In all honesty, when this was proposed, we had some good discussions, some of the planners in the department, as to, well, this seems a little excessive to almost 4 times what was approved. Although it's worth acknowledging that 200,000 gallons for a cultivation of this site seems quite low as well. And so really what we wanted to do was to, I think, highlight that concern and bring it in front of the commission to see, what the feeling was here. So I think it's fair to say how we typically do our analysis of water use, and Colin hit on this pretty well, is how big is the parcel, how much water is this related to how much water is actually potentially available on the parcel, and really that's not much here. But we also are a little hesitant about supporting what might be viewed as excessive water use. And so I think really what we wanted to do is frame this for the commission is what seems to be the sense from the commission as to where that line is.
Yeah, that makes sense to me. I think, well, at least how I've read a lot of, again, I'm very new up here. I haven't even been here a year, and still very new at looking at cannabis projects. But how I've interpreted staff reports is they're looking at the ability for the property to recharge the requested annual gallons. But sort of sometimes it notes gallons per square foot, sometimes it doesn't, and it's not really clear if that is also being used as a sort of a criteria to determine the reasonableness of the ask. So am I hearing you correctly that is done by staff as well?
It is, yeah. I think, in all honesty, there is a lot of concern by the public about the amount of water being used for cannabis. And so, given this request did seem a little unusual, we felt it was better to bring it forward for the whole commission to have a discussion on. That said, as Colin mentioned, we do feel that findings can be made because the property is large enough that the impact on the groundwater resource probably is very, very small.
If I could kind of add to that, one of the things that we look at is, particularly if the proposed water use is too low, are there other sources of water that they may be tempted to utilize and have that go unreported? So if something's too low, that becomes a little bit of an alarm that perhaps we should be looking deeply into what is the source of water, what are alternative sources of water, and what are the cultivation techniques being utilized to justify that. Obviously, if it's dry farming, a low water use is expected. If it's growing in bags outdoor in a very hot area, they're going to use more water. The other thing that kind of gets raised with this is when you have to ask the question, if there's too much water being proposed, why?
Commissioner Scavino.
Yep, I'm going to make a proposal. I do support the rainwater catchment ponds. I'm fine with having a backup well. I think we should be monitoring water use and encouraging conservation. I would like to propose that we increase the amount of water irrigation project from 200,000 gallons to 600,000 gallons, which is a threefold increase, equivalent to about 18 gallons per square foot per year, which I think will encourage the applicant to, is enough for the applicant to produce a good crop and still encourage good water monitoring practices and water conservation. And frankly, if after you get your farm set up and in use and you do your water monitoring and you find a need for increased water, then you would come back again potentially for another amendment, but you would have better data and information for us to consider about your farming practices and how much water you actually need.
I just want to make a comment on what Director Ford said before. Commissioner Scavino, I agree with what you said, but if somebody is over permitted and so therefore they're not using all their water for their crops, are they legally allowed to sell that water to, say, someone who doesn't have a permit and isn't reporting?
Not legally, no.
Okay, thank you.
Mr. Curriasi.
I appreciate this discussion, and to clarify, I was also curious if, I'm happy to hear that there is this gut check by staff, and so one of my thoughts was, is there a practice where applicants will, is there a pattern of requesting more water than needed? But I guess sort of clarifying again that staff does do this sort of water intensity check and makes sure that not only the annual use, but the use per square foot is sort of reasonable with what they see in industry practices.
Yes, absolutely, and it is something that we're looking at when we go out to do inspections. I don't think it was a couple months ago we had one that came back to the commission because we had it discovered during inspections that they were using much more water than they had been approved for, and so that's something that we're paying real close attention to, both at the permitting stage and then in the monitoring stage.
Thank you.
I guess I just want to bring it back to, sorry, I derailed your comment, Commissioner Scavino. His proposal of, so we're currently, the staff report says 759,000, but the number that was thrown out was 600,000. So I just wanted to bring it back to that since I had derailed your comment.
Go ahead.
I'm trusting staff and their experience on what a common water intensity usage is, and so it sounds like 15 and 18 is somewhat reasonable, and so given that, I'm okay with it.
Yeah, I generally feel the same. If that's the number that we've permitted before, then I support your comment.
So, I hear multiple commissioners saying they would be good with the 600,000 gallon and about 18,000 or 18 gallon a square foot. So maybe, being as that's our sticking point or the question, maybe someone might want to make a motion. Commissioner Curriasi?
Sorry to disappoint you. I do have one other discussion point I'd like to bring to address staff.
Okay.
So I did go back and watch the July 6th approval of this permit, just to kind of get a sense of what the commission was feeling, because I know there was a 1 no vote. And it was brought up that there were a number of violations regarding this applicant, and so I wanted to check in with staff on how this applicant has been doing to address those violations before we go ahead and award an additional, more water to this project.
It sounds like there was a transfer of application, if I heard.
Correct.
That.
Yes, there was a transfer of the application, and there was a number of conditions, I think, that needed to happen before they would be able to be considered in good standing. It doesn't appear that they've cultivated since transferring, so we haven't gone out to do any substantial inspections. They haven't had a state license either for this entire time. So I think what they're trying to do here is set themselves up for success by, proposing a well and increasing the water use to something that seems reasonable. If they are able to obtain a state license, we would expect to be out there doing an inspection pretty soon.
Thanks. And to clarify, the permit was under a different holder when those violations were occurring.
That is correct.
Okay, thank you.
And then to piggyback, being as we heard testimony that the plastic has been cut off through satellite imagery and all that kind of stuff, you would know if they're cultivating or not cultivating. That's why you haven't had to go on site, correct?
That's mostly correct. One thing that we're not entirely sure about right now is actually if we have been on site, because we do sometimes go out to sites even if they're not cultivating. Generally, if we're able to verify that they're not cultivating, those become a lower priority for us, and we do satellite inspections.
Thank you. I was just trying to piggyback that counties doing their due diligence, why they're not state licensed, is that there was a project at one point in time that didn't have a state license that was cultivating and trying to avoid an inspection or something like that, if I remember right, sometime in the last 12 months. Director, you?
You've been having a discussion, but I think you're still in search of a second.
I think he's in search for a first.
I was trying to get Commissioner Scavdall to turn his into a motion.
Can I, it's one of the things, so just to final clarification, are there any, I understand it was a previous property owner, are there any outstanding violations like water board or anything that would need to be, that still need to be remediated under the new ownership?
I don't know that we have the answer to that question. There is conditions that were applied to the original project and again would carry through on these that require them to demonstrate that those violations have been resolved before cultivation can occur. And so we may be able to dig into this a little bit more. It might take a little bit.
No, I think that's, as long as there's a condition that explicitly states any outstanding violations from a previous property owner, then that's fine.
Absolutely.
And I think, would that satisfy you? Okay, wonderful.
Because I just want to piggyback on that. If there's violations, you can't get a state license, and the county wouldn't approve it, and you can't get a state license without the county checking the box back to the state. Is that still the process?
Yes.
Okay.
I would like to propose a motion for modification of the conditional use permit to add a well as an additional water source to the project and increase the amount of water used for irrigation annually from 200,000 gallons to 600,000 gallons by adopting the next resolution, which does the following: finds the Planning Commission has considered the mitigated negative declaration for this, for the commercial medical marijuana land use ordinance and addendum that was prepared for the project, finds the proposed project complies with the general plan and zoning ordinance and approves the conditional use permit modifications subject to the recommended conditions of approval, which would include the annual irrigation, increasing the annual irrigation to 600,000 gallons.
Second.
Okay, we got a first and a second. Just want to clarify in that, I remember in the presentation, there was something about the rain catchment pond was actually capacity was larger than originally approved. Is that encompassed in the findings of this?
It is.
Okay,
It's in the, they have to get it permitted
okay,
at that capacity.
okay. Commissioner Curriasi?
Was there, I thought there was a storage piece to your amendment as well, with the
I did
500,000?
not, the current conditions say that there's a rainwater catchment pond of, I forget what it is, 519,000 gallons or something like that, that has to be permitted. So I didn't go into that. I just said that the cap is 600,000 gallons and they're going to add a well.
That makes sense. I think I was just misunderstanding. The feeling is the existing storage on site is sufficient. Is that right?
Correct.
Yeah, okay.
Commissioner West? So, same thing on this project. I will do, it's a larger project and there's some items that people could not like, so I would do a roll call vote on this as well. So if we could do a roll call vote, please.
Commissioner Scavdall,
Yes.
Commissioner Mulder,
Yes.
Commissioner West,
Yes.
Commissioner Curriasi,
Yes.
Commissioner McFarland.
Yes.
Thank you, motion carries.
Motion carries. Project is, or modification is approved, and we do not have any items pulled from consent, so now we are at workshop, synthetic netting use in cannabis operations. I'll turn it over to staff. Full disclosure, I am a cannabis cultivator, so I don't know how you want me to deal with my participation.
This is a county-wide issue. This doesn't directly affect you, so you're not restricted in this discussion.
Okay. That's kind of how I viewed it. I just wanted to make sure I called it out.
I'll actually just add, I think myself and a few other commissioners appreciate your view because we're not cultivators, so I would encourage you to please be active in this.
I'm mainly ears right now.
I have examples. Could I approach Ben? Could I offer these to you guys to touch and feel?
You can approach.
Yeah.
Go ahead.
Check it out. Here's some monofilament netting for you. Here's some for you. Just gonna pass it around. This is synthetic netting. This is what we're talking about today. And its use in cannabis cultivation activities. Okay, so today I'm going to be talking about using synthetic netting in cannabis cultivation, the opposition to and support of the use, and then staff recommendations. I suppose I should start with kind of the crux of it. Eventually, we're going to get to the point where I'm going to ask you for direction on how to move forward as far as regulating or navigating the use of synthetic netting. There isn't really like a resolution tied to this at the end. Okay, so using synthetic netting. Synthetic netting, plastic or nylon, also referred to as monofilament netting, is a type of trellis which is frequently used for cannabis cultivation and other agricultural activities. This type of netting is characterized by a single strand or thread welded at the joints of intersecting strands, which kind of provides a durable, mildew-resistant netting that supports growing cannabis plants. It's also sometimes used for fencing. The use of synthetic netting is, for cultivation specifically, is not addressed in either of the county's commercial cannabis land use ordinances. However, the conditions of approval for many cannabis permits restrict the use of synthetic netting or monofilament netting. You'll see on the right one of the kind of standard uses. Its use is trellising, providing additional support for the branches of the cannabis plant. And then usually it's sold in rolls and looks like that when it's being stored before its use. The source of the condition of approval often comes from CDFW. This is an older edition. Okay, that's okay. I could read it out, but essentially they say, to minimize the risk of wildlife entrapment, CDFW requests the prohibition of synthetic netting and then provides a number of alternatives: geotextiles, fiber rolls, or netting used of loose weave mesh like jute, hemp, and coconut fiber. Oftentimes, the alternative I see is jute. Yeah, this is an older iteration of the presentation, so it's not exactly in the order that I expected, which is a little bit frustrating, but that's okay. So here is a series of photographs of on-site use and occasional misuse of synthetic netting. Again, a number of the projects in Humboldt County have a restriction on the use of synthetic netting, but use it nonetheless, because we'll get to that later, but they argue there isn't a good alternative. So examples of the use on site. On the left, you'll see trellising. This provides stability. On the right, netting for fencing. It's to exclude deer, usually, from cultivation sites. Here's a couple more examples of how it's used. Occasionally, it's used in greenhouses in long rows. Alternatively, it's used around kind of big green monster style of outdoor cannabis cultivation, usually in a series of layers. So as the plant grows, it reaches layer 1, it spreads out its branches. As it reaches layers 2, it spreads out again and it can hold itself up. Here is monofilament netting, smaller gauge, I think a 2-inch gauge, being used as netting. And then again, on the left photo, you can see the use as trellising. Occasionally, the cultivators are negligent when it comes to storing, disposing of, and using monofilament netting. The stuff is pretty hard to deal with when it's bundled up, and as CDFW comments, it does pose a threat of wildlife entrapment. In your staff report, attachment number, insert the correct attachment here. In one of the attachments is a rather graphic series of photos of animals trapped in synthetic netting. I didn't include that in my presentation, but if you're interested in digging a little deeper, you could look into it. Yes, sir.
Those just appeared to be sort of like stock photos from CDF. None of them were actually Humboldt County, evidence of Humboldt County projects that I observed, so.
I think that's a compelling point. I think it's...
I'm not saying that it doesn't happen, I'm just saying that it's interesting that CDFW didn't have any examples specifically of wildlife entrapment related to Humboldt County projects that they submitted.
I hear you.
Observation.
I just have to comment that my assumption would be that when this happens on property, the owner isn't going to call CDFW and submit a picture. So I understand your comment, but I give a little bit of deference, and I believe that a stock photo provides the same evidence as it,
Perhaps it's just that CDFW is raising the issue, so it would seem that they would actually have real evidence to support versus
I
going
get
to the
that.
internet and finding a picture of an example. That's my.
I will say, we have roadkill in areas that we don't always have photos of, but we have documented verbal cases with Caltrans. Like we know where an otter has been hit. We don't have the photo, so I
I'm
give
not saying
them
it
a
doesn't
little.
happen. I was just disappointed that CDFW didn't actually provide
That's
real
fair.
evidence to support their case. I'm not disagreeing that it actually happens.
Yeah, just both sides of the point. Thank you.
And then I think the final example of misuse on site would be the examples that you have in front of you. Occasionally when the cultivation season is over, rather than lifting and removing the trellising or pulling the plants out from underneath, the trellising is cut all the way down it, and occasionally the small pieces are left and not properly disposed of. There are alternatives and best management practices that can be used. The recommended alternatives from CDFW include jute netting. It's a natural fiber. It's on the left. I don't have an example of that, but it's kind of like a rope. It feels like rope. And then on the right-hand side, there are a few cultivators that use these large kind of steel grates or steel cages. They're about 8 feet tall, and they provide a similar kind of support structure. Occasionally, those are used in concert with monofilament netting or synthetic netting, kind of, again, at the same levels. But it's a pretty common alternative. I mentioned at the beginning that it's also used as fencing to kind of exclude wildlife. An alternative to plastic netting or plastic fencing is steel fencing. And additionally, the steel fencing has a second kind of function. In the case where one is using monofilament net or synthetic netting for cultivation activities, installing, for trellising specifically, installing large steel fences around the entire cultivation area effectively excludes things like deer from the cultivation site, and therefore, essentially, for lack of a better term, mitigates the potential impacts of wildlife entrapment or the potential risk of wildlife entrapment. And that would be, I think, considered a best management practice. So in the circumstance where the decision is made to enable cultivators to use synthetic netting for trellising or cannabis-related activities, perhaps part of it would be you can use it as long as you have a fence up around your cultivation area. Some other alternatives are bamboo teepees and bamboo stakes. More labor intensive. It involves essentially zip tying the plants to bamboo stakes to hold them up. And finally, I went to a dry farm down in Holmes Flat, and the operator explained she had, I mean, just acres and acres of cannabis. Not a single example of monofilament on site. And she explained, well, I grow from seed. And when I put a seed in the ground, it drops a much deeper taproot. My plants are a little bit more stable. That was her kind of explanation for why she wasn't using monofilament netting, because it was in my mind at the time. Whereas the alternative kind of start for a cannabis plant is a clone, which I can't say from any scientific perspective that this is the case, but the root structure is perhaps not quite so robust, and so the plants have a little bit more of a struggle when it comes to holding themselves up, which is the primary function of the plastic netting, to hold the plant up. And so we end up at opposition and support. So again, in their initial response, CDFW affirmed their position that they wanted to restrict the use of cannabis, or they wanted us to restrict the use of cannabis, of trellis netting on cannabis cultivation sites. Today, and you'll see in supplemental number 1, CDFW provided a follow-up response and suggested that acknowledging the risk posed by monofilament netting to wildlife, they would nonetheless support the alternatives that were proposed by the county planning and building department. I haven't gotten to those yet, but they are to revise the land use ordinance to prohibit monofilament for all types of cannabis cultivation, or all permit types. Revise the land use or alternative 2, revise the land use ordinance to provide for regulations around the use of synthetic netting in cultivation activities, and provide for guidance as far as the proper storage, disposal, and use of the netting. And rather than blanket restriction, enforce mismanagement of synthetic netting rather than its use. In general, the opposition to synthetic netting is that it poses a risk of wildlife entrapment and entanglement when it's improperly stored, disposed of, or used, and it can be a plastic pollution source when it's used of or disposed of irresponsibly. The argument in support of synthetic netting is that suggested alternatives, jute, hemp, etc., retain moisture and deposit fibers that foster the growth of mold in cannabis, which causes the product to become unviable. And the second point is that alternatives are expensive. I go into a little bit more detail in the staff report as far as kind of the cost differences. Third is that best management practices work, making sure that the byproducts are thrown away, making sure that animals are excluded from the site, limits the potential impacts. Additionally, the material isn't restricted in other agricultural practices. It doesn't seem to be restricted in other jurisdictions. Again, in the staff report, I go into a bit more detail about reaching out to other county jurisdictions that have legal cannabis cultivation. I also talked to other CDFW regional, I don't think they're called chapters, but regional offices, and they didn't have too much to say about it. I'd say that their comments were pretty insubstantial. And then finally, that it's not formally restricted in any of our published code or regulations. And finally, I suppose, is some of the public comment that we received. One of the local consultants, ETA Humboldt, provided an example of best management practices, which is an attachment to the staff report. And essentially, they were arguing that the proper use and disposal of synthetic netting poses minimal risk to the natural environment. And I could go through the best management practices if you want me to, or would you rather me not?
I'm happy to hear them if you have them prepared.
I do. Okay. So the first best management practices that they recommended was to store rolls of undeployed monofilament netting or plastic netting in an enclosed space to prevent accidental wildlife entrapment and to reduce material degradation. Best management 2 was to secure both ends tightly to cultivation support infrastructure, to trim extra material at the ends along the sides of the installation site, and to dispose of the scraps directly into sealable trash receptacles to avoid littering. The third, to minimize the number of separate sections deployed at the cultivation site. One-piece sections of the plastic netting, they argue, supports plants more effectively and reduces the likelihood of improper material disposal. The fourth one is to avoid installing unnecessary layers of the netting until the plant transition period is well underway. This is, as I mentioned, there's usually 2 layers of it, and as the plant grows, it reaches the layer above it. Occasionally, cultivators will have 2 layers at the beginning of the season. As I interpret this one, it's wait until the plant gets close to the second step or the first step before you install the netting. The fifth best management practice that they recommended is to conduct routine maintenance inspections of the support systems that include PTN. They use that as plastic trellis netting, PTN. They recommend carrying sharp scissors and replacement fixtures, i.e. zip ties and plant tape, to repair broken or damaged sections, and again to immediately dispose of microplastic waste in a sealable trash container. Number 6 is to reuse trellis netting. They say reusing plastic trellis netting can help commercial operators cut costs. Any fixture should be immediately disposed of in a sealable container. A little bit of repetition here. The reusable sections of PTN may be neatly rolled up for cleaning and immediately stored in a sealable container inside an enclosed space away from the cultivation area. So this is, I think, 2 parts, but reuse the trellis netting rather than cutting it up at the end of the season. And then, again, and I don't think it's, overstated, please ensure that the waste is immediately gathered into sealable containers and removed from the cultivation area as soon as possible upon the completion of harvest. That is the series of best management practices that ETA Humboldt recommended. And so on to our recommendations. Our first recommendation, primarily, is that the Planning Commission provide guidance on the preparation of a resolution governing the use of synthetic netting in cannabis cultivation. A little bit esoteric, but we could kind of workshop it in a minute. The alternatives to the staff recommendation is a no-change alternative. I think one part that I missed in my earlier presentation, but I did explain in the staff report, is that based on whether or not a project is approved through a ministerial process or a discretionary process often affects whether or not it has a restriction. If the project was approved through a zoning clearance certificate, because there's no regulation in our code, they can use plastic trellising as much as they'd like. Whereas if it's a conditional use permit or a special permit that receives comment from CDFW, generally we incorporate that recommendation into the conditions of approval. And as the Planning Commission has approved many cannabis permits with that condition of approval incorporated, we find that out in the world, depending on your zoning, depending on where you are, you'll find projects that are using the trellis netting fully within their rights. We'll see people who are not using the trellising netting specifically because they're restricted, and we'll see people who are using the trellising netting saying, well, why is he going to use it? I mean, I need to use it on sites where it's otherwise restricted. And so I think that the majority of this conversation is trying to facilitate at least a pathway for the discussion. And so the alternatives. Alternative 2 is to revise the land use ordinance to prohibit monofilament netting for all permit types. And then 3 is to revise the land use ordinance to provide regulations around the use of synthetic netting in cultivation activities. We did also receive a final hour public comment today, which I thought was substantial. That's supplemental number 2. This public comment was from the Humboldt County Growers Association, and I kind of summarized it here. Their fourth alternative is to not revise the land use ordinance, but instead establish clear policies and best management practices that promote the responsible use of synthetic netting in cannabis cultivation. Essentially, this is a relatively long comment, as you'll see. It's a few pages, but my summary says, guidance documents and best management practices should focus on education and proper disposal rather than imposing blanket prohibitions and disproportionately impacting one industry. Legal cannabis farmers are already operating under stringent regulations, and this added restriction would create unnecessary hardship without significantly addressing the broader issue of plastic waste. Their recommendation is that we essentially develop a guidebook to provide ideas for best management practices. If I can speak somewhat subjectively, I think that alternative number 2 kind of meets this same, or I guess alternative number 3 meets this same goal, but through a more concrete pathway where we create policy and incorporate it into the code that provides for recommendations on best management practices, or provides boundaries for what is an appropriate use and an inappropriate use of synthetic netting, and guides the enforcement of it. That, I think, is the conclusion of my presentation. So thank you all for listening.
Any clarifying questions for staff? Commissioner Curriasi?
Can you clarify again the difference between staff's proposal and the land use ordinance option? So basically the resolution option and the land use ordinance option?
Yes, would you like to go into
Sure.
detail?
I think
Just kind of loose.
I think the language that was used was maybe confusing with resolution, because what we really are suggesting is that of the 3 alternatives, 1, do nothing, right? The other 2 would be to amend the zoning ordinance. And so that would occur through technically a resolution adopted by Planning Commission and then the Board of Supervisors. So that's a little confusing probably to reference resolution there, but yeah.
Any other questions, clarifying? I have one clarifying. So, if I heard you correctly, the restriction of monofilament netting from CDFW is due to entrapment, and they recommended using jute netting instead. Does jute netting and monofilament netting have similar size spacing?
Yes.
Okay. Thank you. Go ahead.
So I just want to, in reviewing this, I understand the concerns about plastics and plastic netting overall. So again, setting that aside, my concerns, 2 concerns were, one is that we're considering imposing, or we are imposing, a regulation that doesn't seem to be consistently applied across the state. So in one sense, we're perhaps piling on a regulation that's, at least local businesses are saying, is unfair or puts more burden on them than their competitors in other parts of the state have to deal with. And then 2, we're inconsistently applying that depending on whether you come through the zoning process or to the Planning Commission. Both of those concerns bother me in that they, I don't like the idea of putting overly burdensome regulations on local businesses or regulations, special regulations for Humboldt County businesses versus other businesses, and certainly don't like the inconsistent application of that. That is in fact what causes businesses not to come before us to seek permits, and in fact drive some of them away from us. Or you even talked about the fact that some businesses are just accepting that we've put it in, we put this condition of approval on them, and they're ignoring it because they think it's overly burdensome, or in fact their neighbor doesn't have to do it, right? So that in my mind is not right, and somehow needs to be corrected. I'm not yet on to what the solution totally is. Part of me feels like an agency that has broader authority across the state, if they really think this is an issue of concern, that it belongs in their world and not in our world, that perhaps we should back off, which would maybe put more pressure on CDFW or Department of Cannabis Control or Regional Board or somebody else to take on this topic. Why do we feel like it's our burden to solve this problem for all, just in Humboldt County? So I'm still wrestling with that, but that's kind of where I am right now, trying to figure that out.
Mr. McFarland.
I think our end result will be the same. So I'm not trying to, start anything here, but I do disagree with some of what you said. Sure. There are a lot of statewide laws that are now in effect that started with county measures. And so, someone's got to start that train, whether it's smoking or the plastic bag ban.
Yes, we're trying to clarify.
And so I do agree that it has to start somewhere.
I let us get a little deeper.
That being,
I admit, I apologize.
That being said, I do recognize we don't want to put another restriction on an industry that, is a big part of our county. So I think that finding a middle ground would be the most important. Like, I don't want to completely rule it off the table. So I think finding a middle ground, really focusing on that waste would be the way to go.
Yeah, and again, I haven't established a position. I'm wrestling with it.
And the other thing that you mentioned was being fair. So I know you were talking about in the context of the cannabis industry, but we do have to think about other industries that are, allowed to use this material and do waste it. And so we're talking maybe some fishing industries, a lot of fishing gear waste. So I do want to be cognizant of that statewide issue that still exists.
Okay. Any other? Commissioner Curriasi? Let's try to stay a little more to just clarifying questions or comments.
Yeah, and I'm happy to this is sort of in the middle, so I'm happy to take it to a different time as well. But I'm curious to staff if there is a similar ordinance around the use of herbicides and pesticides. Curious if there's sort of an example there.
Those are regulated differently, so we tend not to get comments about those. They're regulated both by the County Coupa program, and then they're regulated through the DCC licensing, which requires testing. And if certain things show up in the cannabis, it's not a viable product.
Yeah, I guess I was imagining well, I'll hold it off. It's starting to become discussion.
Okay. I have one more clarifying. So at what point in time have we tracked back with this presentation? Because following this, originally CDFW's comments was no use of monofilament netting in erosion control. And I know many projects that literally just have that. And then slowly there was this cultivation operations was added into it. Have we tracked back to when that date happened?
Well, it's important to note that the cannabis general order by the water board, the state water board actually prohibits the synthetic netting for erosion control purposes, but that's for erosion control only. I believe, and maybe Colin has done a little bit more research here, but I think it was sometime around 2019 that comment started to make its way pretty standardly into the CDFW responses. And so at that time, those comments were coming to the Planning Commission. The direction we felt was to include those as conditions of approval. And so that does kind of hit on Commissioner Skavdal's concern that there are certainly some permits out there that do not have that condition.
I don't have a specific date.
Okay, yeah, around 2019 is my recollection.
Okay. And I guess I would say full disclosure, I do have a permit that doesn't have one of those requirements. So I've seen that language from CDFW, like where it says no use of monofilament netting in erosion control. And then slowly, like that just got added to cultivation activities. So I will now open up public comment. For those of you in the room first that waited, you get the opportunity to speak first. 3 minutes to each person. Looks like we got 2, 4, 5, 6, 7, 8.
Good evening, Commissioners. Suzanne Mays with Margot Advisors. I did actually have the clerk pass out something I'm going to refer to. We also did a little bonus for you. We have laminated no less than 10 of the agencies, state and federal and county, or actually county isn't even part of this. No less than 10 agencies that our cannabis farmers have to take contact with, enroll, report, pay fees, all the above. Hopefully that'll help you folks in determining sometimes not knowing if things are regulated or not. Given the significant usage of monofilament netting in this industry, we've battled during permit approval meetings to have permit conditions properly align with the actual state water board agency, which mandates as follows: monofilament netting not to be used for erosion control, period. Respectfully, agency overreach has been something that our local cannabis operations have continually faced in the last 8 years of legalization. The stigma against these farmers is real, alive, and well, even after 6 years of state licensure. At this point, I'd like to call your attention to staff report, page 3, paragraph 2, second sentence, referring in reference to CDFW regional office. It appears that Humboldt County may be unique in imposing restriction on monofilament netting. Something important to know is that all farmers are required to enter into lake and stream alteration agreements or get waivers approved. They're customized by Fish and Wildlife for their farms. Not a single agreement in the past 8 years that we've been in business have we seen the prohibition from the county, what the county is using. CDFW themselves actually have, and this is the first attachment, marked in pink at the bottom, it says 2.9 of this LSA excerpt heading is prohibition of plastic netting and erosion control measures. It has nothing to do with all cannabis activities. It is a water board mandate that CDFW feels strongly about and has put pressure on the county to include it. I want to communicate clearly that we do understand the risk for wildlife when this product is misused. We've seen it. We can provide pictures, actual pictures. However, given all the oversight, okay.
You're out of time, I'm sorry. I meant to say 30 seconds and I apologize, this thing right here cut. So thank you for keeping it at 3.
I'm asked,
Yes?
This is a workshop. Do we actually have timing?
Well, I'm trying to be fair because I got 1, 2, 3, 4, 5, 6, 7, 8. So and then 2. So I'm trying to be mindful of 30 minutes of comments.
I'm sure they'll support the same as what I'm saying. We understand, we're just asking for some leniencies. There's more than enough oversight, regulation. The county should be able to do something. I think most importantly to know is what we show
Thank
from
you.
all of ours is.
I'm trying not to show extra favoritism to the cannabis industry, being as I'm a cultivator, so I'm trying to tiptoe a fine line.
Thank you.
Yeah, I think plastics are a big issue in pretty much every industry, and trellis is critical in my line of work. And if you guys could help us find a way to use it consciously, that would be awesome. And thank you.
Okay, so being as everyone in person has spoke, we'll now go to the phone. Is 3729 already unmuted, or am I looking at that? Okay, you got 3 minutes.
Hi. Great. Thank you so much. My name is Shannon Hughes. I'm a licensed cultivator here in Humboldt County. My comments are going to be pretty similar. This feels like it's just specific to cannabis, and that's something that I think all of us are a little tired of. We would really appreciate parity, and the fact that we seems to be only talking about cannabis is, I think, the problem. The language in the staff report and the CDFW report do suggest that this is not something that is a problem across the board. You know, not all farmers are irresponsible with this material. We are some of those folks that painstakingly label with the painter's tape the dimensions so we can take it off carefully, store it properly in a shipping container, in a bag, and then pull it out the next year for use. We also have all of our cultivation area fully fenced so that no animals, we don't want our dogs getting tangled up. We certainly don't want deer getting tangled up. So we are an example of a farm that is already using best management practices. The CDFW doesn't provide any statistics. How many farms in Humboldt County have they cited for these issues? The fact that, you know, as John Ford referenced, you know, these are stock photos. They could have also provided some more concrete statistics for what they are finding in Humboldt County, which would warrant this type of prohibition. It's odd that plastic and like deer fencing is being wrapped up in this, because you can actually get some pretty thick, rigid plastic deer fencing that you can pull really tight. Homeowners use this. I'm sure other agricultural industries use this. And so the fact that that would be wrapped up in this is a little bit confusing, because it does not pose the same risk in my mind as a thinner, more flexible monofilament trellis. I do understand the risk to using the monofilament trellis. I'm not naive to that. Just wanted to say that a blanket prohibition and regulation overreach is not going to be the answer here. Let's rely on best management practices and educate farmers about how to properly use this material. I will say that it is cost prohibitive to use any other material. That's why we reuse ours every single year. So I just want to be one of those farmers out there that's saying, please don't prohibit something that is a tool for me to be able to use. It helps keep my costs down. We are doing everything we can to be good stewards to the wildlife in our on our land. And I just wanted to give my 2 cents. That's all I have.
Thank you. The next commenter is Vanessa Valeray. Hopefully, I probably didn't enunciate that correctly. 3 minutes.
That's fine. It's Vanessa Valeray. I just want to let you know that my name might pop up again, but it's not me. It's another member of my staff.
Okay.
Okay. I just want to address some things pretty as quick as I can, pretty succinctly. Starting with the staff report. In the staff report, there is a paragraph that talks about many permitted farms have been repeated violations because they will not stop using synthetic netting. And it says for some of these operations, suspension and revocation of the permit may be the next step. I feel that permit suspension and revocation based on an inconsistently applied regulation surrounding the trellis is an improper and arguable unjust use of this power over permit holders. There's no viable alternative to plastic zip ties or metric tags or petroleum-based engine oil? And will these essential products also in the future result in suspension and revocation? I feel like there are just several progressive, corrective, and or punitive actions that should be taken before revocation, education, and benefit of doubt should be granted before punitive response. Moving forward with the staff report, it says that it may be appropriate for the county to, quote unquote, it may be appropriate for the county to consider amending the ordinance to address the use of synthetic netting. The key consideration is whether to prohibit the use of synthetic netting in all cases. And I would argue that this would require a change to all the ordinances previously passed by the county. And since it's imposed on some permits and not on other permits now, we would have public comment. And I was just worried that this would be like a very big thing to try to unravel to then prohibit it altogether. I would also task that we find evidence in the IR that would support that this would be warranted for just our county. In the staff report, they give alternatives or the recommendations, the no change alternative. I would say that this is a bad way to go because it admits the inconsistent regulation between discretionary and non-discretionary permit types. Commercial operators reasonably perceive inconsistent regulation as unfair system of punitive violations and noncompliance. The no change alternative offers no real perceived value to operator financial interests, and the no change alternative publicly acknowledges inconsistent regulation regarding irresponsible and improper use of cultivation material, but fails to provide any reasonable action towards protecting wildlife. Just kind of moving forward, I really believe we need to go with alternative 2,
30
which
seconds.
would be the most fair and beneficial use to the wildlife and the stability, and clearly defined DMPs with penalties for non-compliance could be adopted and amended into current regulations. Very quickly, I just want to point out in the CDFW comments that there is an unfair assumption that because rural landowners don't have a way to get rid of their garbage, but that's not true. All domestic landowners in Humboldt County use up to 17 different dump locations within Humboldt County that all will take the trellis netting.
Thank you
And
for
there's some
your
other things I wanna
comments.
say
I'm
to other
sorry I have
people
to
like
cut
that.
you off. Thank you for your comments. I apologize, but I'm trying to do really try not to show any favoritism towards commenters, so I apologize. I gotta cut you off at 3. Actually, I don't even get to cut you off. I have help. So, Kelly, you are up. And unmute. Should have 3 minutes.
Thank you. Can you hear me okay?
Yes, I can.
Okay, great. Hello, I'm Kelly Flores with Martyr Advisors. Since there's a number of new commissioners, I wanted to take a minute to just remind the commission of how highly regulated this industry is. Suzanne mentioned the laminated handout, so I'll be referencing that for you. It just provides a conceptual view. So for example, farmers have to have permitted septics or commercially serviced toilets as required by the Department of Public Health. If they store 55 gallons or more of fuel, they must enroll in the Department of Health Hazardous Materials Registration. They must be enrolled in the State Water Resources Water Quality Program, and that program requires a site management plan for them to identify exactly how they're going to protect water quality for that farm. They have to provide annual reporting to that agency in detail, including things like the number of plants and how much nitrogen and phosphorus was used for the total of the prior year. The Department of Cannabis Control requires that all plants and stored products be individually tagged for the metric track and trace online system. And the DCC does conduct annual inspections to ensure all operations are in compliance in addition to the track and trace. Now, if a farmer has water diversions, even for domestic use, they have to register with the Division of Water Rights, and they must have a Fish and Wildlife Lake and Stream Alteration Agreement. And that agreement has to be renewed every 5 years, which includes inspections from the agencies. Now, if they're using diversion for irrigation, they're only allowed to use it for 5 months during the winter period. If they have a culvert and that culvert doesn't meet the size potential of a 100-year flood event, they need to have an agreement with Fish and Wildlife. They have to replace that culvert even if it's in perfect condition. The Department of Agriculture requires weighmaster certification. Their scales have to be recertified every year. And if they use an EPA registered pesticide, they have to log that usage, and submit it within a month to Department of Pesticide Regulations. They also have to adhere to a very long list of banned pesticides, which they cannot use on their farm, or their product will fail state-certified lab testing. There's also other agencies that get engaged. The Army Corps of Engineers, they weigh in on wetland delineation. Folks near the Dinsmore Airport had to get airspace variances from the FAA. Now, there's a lot more examples that I don't have time to point out.
30
but
seconds.
My point is, monofilament netting is not a significant environmental issue for these farms because they are so scrutinized. It is important as a tool in managing a cost-effective operation. So what we ask is that you please choose to support the option to advocate for best practices instead of prohibition. Thank you.
Thank you for your comments. Next up is Madeline Delap, it looks like.
Good evening, Commissioners. How's my audio quality?
I can hear you.
Okay, great. Thank you. I am speaking tonight on behalf of the Humboldt County Growers Alliance, and I really appreciate the opportunity to give comment on this extremely important issue. As mentioned, since 2019, there have been inconsistent application of these prohibitions on plastic trellis for farmers who have been permitted since 2017. So this is an issue that is very important. This is near and dear to our heart, and this is affecting a lot of our people. And so I'm really grateful that we're having this conversation tonight, and that I'm really looking forward to having a uniform application of rules across the board. So I also want to say, you know, none of us want to see entangled animals because of plastic. I mean, my social media feed is constantly showing me animals entangled by plastic, but I'm not seeing monofilament netting in Humboldt County affecting our local wildlife. I'm not saying it has not happened, but it is not the issue that it once was when we had 10 to 15,000 illegal farms operating across the county, when today we have fewer than 700. You know, as Suzanne and Kelly have mentioned, we are a highly, highly regulated industry. And, you know, as already mentioned in the staff report, plastic trellis is only prohibited in erosion control. And this has then been an additional add-on that the Planning Commission has only put on discretionary permits. And, you know, and I just want to say, you know, I had this, you know, we submitted comment a while ago, earlier this evening, but, you know, trellis is so important that our county's economic development department named Project Trellis after trellis because it's such an integral part of our industry. So to talk about the alternatives, alternative one, just the blanket prohibition would be absolutely devastating. Please do not go down that route. To the point of alternative two, developing actual regulations, I think that if that is the direction that your Planning Commission decides to go, completely understandable and reasonable. But I do want to say, developing a regulation through this resolution process is going to be time intensive, more workshops. You have to amend
30 seconds.
two land use ordinances, and then go back before the Board of Supervisors. I really do think that this can be addressed through policy changes, just like you started to incorporate this purely through policy. You can undo it through policy. So I think that you're going to continue to hear this is needing to be addressed, but if we can do it through policy and not regulation, that would be better. Thank you.
Thank you for your comments. Next up is Marissa, ETA.
Yes, hi, thank you for allowing me to speak. I just wanted to agree with Mr. Mulder when he said that originally the condition was just for erosion control material, and over the last couple years it has kind of morphed into erosion control material and or cultivation materials, and there really hasn't ever been an explanation as to why that change occurred. I also wanted to point out that cannabis is agriculture, and trellis netting is not banned for any other agricultural use. It's not banned for domestic use. It's not banned in other jurisdictions. And so this does seem to be onerous to our Humboldt County cultivators. It's just one more thing that they have to do that no one else does. Beyond that, it's confusing for the cultivators. As an example, I have a permit holder who has multiple permits. He's allowed to use the netting on some and not others. That's confusing for him. He doesn't understand why he can use it on one piece of property and he can't use it on another. So, it has actually been rather unfair to the cultivator as it's, popping up in these conditions of approval. Beyond that, I will agree with Vanessa's earlier statement that, CDFW says that people aren't taking it to the dump because there just isn't enough facilities, and that's not true at all. There are plenty of, refuse facilities in the area and plenty of ways to dispose of this. All of the transfer facilities take it. And so I would really like to see it incorporated across the board so that everyone could use it, as long as they use best management practices and incorporated responsible use for it. As Madeline said, none of us want to see wildlife entrapped. That's horrible. Nobody wants to see that at all. But I think that there's some common sense here that we could implement, that as long as everybody uses those best management practices and they dispose of it properly and reuse it if they can, that it's a viable tool and we really need it. Thank you very much for your time.
Thank you. Looks like we got one more hand up, and I'm gonna guess that that's we said Vanessa would have the hand up again, so.
Hi, yes, thank you. My name is Matt O'Shaughnessy. I am a cultivator and an environmental land use consultant with ETA Humboldt. Most of the points I wanted to address have already been spoken about, so I just kind of put together a little summary of what I have to offer. Mainly, the fact is that responsible regulation implies progressive process towards enacting regulations, which may prohibit the use of common cultivation materials when other important industries pose a risk to the natural environment. For instance, in-stream road or bridge work, the timber industry, electric, gas, utilities, etc. We develop regulations and best practices for managing that risk and for responsible use rather than prohibiting materials and activities outright. Expanding on that, the results of the recent Measure A initiative clearly demonstrate that a strong majority of Humboldt owners do not support regulations that may endanger local cannabis production. I also want to touch base on a couple of assumptions that were brought forth by some of our agency partners, and this is in no way meant to defame any of our agencies. We have good working relationships with CDFW and the Water Board, but there seems to be an assumption that removing plastic trellis from a cultivation site requires a lot of labor, and pretty much everything in cannabis is highly labor intensive. Anyone that's ever applied metric tags understands that. And then proper disposal of plastic trellis is no more difficult or labor intensive than any post-planting cleanup, picking up pots or soil bags or anything like this. And most of our local cultivators and operators are good stewards of their land. The likely result of our alternative one is increased permit attrition and or willful noncompliance, both of which logically conclude in decreased local productivity and quality of life. Adopting full prohibition may have the unintended consequence of strengthening growers operating illegally without permits and oversight. A full ban on plastic trellis by nature invites noncompliance. Performance standards for responsible material use demonstrates good faith on behalf of the county regulators and is historically more likely to be met with good faith from commercial operators.
30 seconds.
The issue of wildlife entrapment is very real and very serious, but responsibly addressing this problem in a way that does not create additional noncompliance incentives or burdens to a struggling local industry is critical. This is an opportunity for our area to demonstrate concern for environmental resource values while simultaneously developing a model for a blooming industry with nationwide significance. Thank you. Thank you.
Thank you for your comments. Is 3729 unmuted or that just, it has 3 dots? Nope, not anymore, because I thought 3729 was already commented at the beginning. They did, okay. So I'm not seeing any other hands up on Zoom, so I will bring it back to the room. There's nobody else new that has walked in to try to make comment in person, so I will close public comment and bring it back to the commission with staff making some suggestions first.
Thank you, Chair. I just wanted to bring up a couple things that may be embedded within our recommendation that's not entirely clear. First is that we're asking for the Planning Commission to adopt a resolution with direction. That direction would then go to the board if, in fact, you chose to adopt an ordinance or to recommend that the board initiate an ordinance to adopt best management practices. I think our recommendation would lean towards an ordinance for a couple of really critical points. Point number one is right now the disparity between ministerial projects and discretionary projects. If you adopted or went down the route of just a policy document, the policies would affect future permits, would not affect existing permits that have the requirement for the monofilament netting, and would not affect ministerial permits. Because the ministerial permit basically says you're in compliance with the existing regulations that are in effect. What an ordinance modification would do, and it would require some work, is that it would apply to whether you're approved under 1.0 or 2.0. It'd be written that all permits are then subject to it. And we believe we can work a way into it that would allow us to retroactively go back and address conditions that have been applied to conditional use permits and special permits. So I wanted to give you those points to think about as you deliberate.
I'm going to ask a quick clarifying question. Is it possible to be, so some people say is if you open up the ordinances, it's Pandora's box. That's some people say that. Is it clear to say we want to open up for just this scope and keep it to that, so that way we aren't, how would I don't want to say aren't, but you know, people could say, I want everyone to pave their driveways and, you know, listen to 5 hours of comments about that.
I think that could be part of your recommendation to the board to go down that path. Whether, I mean, the board could open up the ordinance at any time regardless of what the planning commission thinks, and you know, sometimes public processes take on lives of their own, so.
The reason I say, because technically we have to ask them to open it up, to authorize us to open it up, is correct? Okay.
I'm sorry, I'm not quite following. So, okay, so you're asking us, are there 4 options before us, or are there 3 essentially? Because like 3, right? Okay, so you're asking for us to give you direction of one of the alternatives to do the resolution, essentially, right?
Yeah, the resolution would basically say we want the board to direct staff to go down this path.
Great, thank you.
Mr.
Can I ask just a historical question? Like, what inspired the county to open up this box and bring this forward?
In all honesty, because there is this disparity between ministerial permits and discretionary permits, and we are finding as we inspect sites that monofilament netting is being used on sites where it's prohibited. And as was reflected in the staff report and a commenter pointed out, is that puts us in the position of suspending or revoking permits for something that may not be such a terrible thing or can be regulated differently. And so rather than to start to take, it's late, I don't have a better term, draconian measures, we thought it would be better to have a public dialogue about it and see if there's not a better solution.
Commissioner Scavino.
So there is another option that you didn't include in here, which is to adopt the non-discretionary permit strategy, which is to allow the use of monofilament netting. Wouldn't require a land use ordinance change. We just would stop conditioning discretionary permits for not using monofilament netting.
That is true.
That would require the industry to self-regulate and follow best management practices. Otherwise, at some point, the industry is not going to be able to use monofilament netting. So we don't have to regulate something always. Right?
Well, I think in fairness, the reason we're bringing this forward is not to add regulations, frankly, but to find more appropriate regulations, because we've got about 500 permits that have this requirement. That it's an existing requirement that we've got to struggle with. Going forward, there's far less numbers. There's about probably equal numbers with ministerial permits that aren't subject to it. So really, at least in my mind, the struggle is, what do we do with that 500 that have this condition on it?
And one option is remove the condition.
It could be, and perhaps, but how to do that without doing it 500 times? In our mind, the most efficient way to do it is to embed something in the ordinance that says, yep, this was applied, but it could be as simple as removing it. That condition doesn't apply, or to do best management practices, which I don't hear the industry saying they're opposed to.
Correct. I don't either. I'm just trying to find a way to not open Pandora's box, I guess, is
if you
brainstorming that idea.
So to brainstorm with you, I mean, I don't know that there's another way to do it, but we'd be perfectly willing to try to find a different way to do it without opening the ordinance.
Can I continue?
Go
If
ahead.
we were to open the ordinance and pursue something like alternative 2, which would provide regulations or BMPs, I think I would like to use the term best management practice versus regulations. And I don't think we always have to have the operators to submit a plan necessarily. We can ask, we can allow the netting, we can require the use, they follow BMPs, we can monitor whether or not they're following the BMPs, but we don't need another plan to be submitted necessarily. And that's coming from a person that made his living as a consultant that loved to write plans. But what do we do with these things? I mean, we're just asking the industry again to submit another plan, and they just, sit there. So I would prefer that we didn't require the operators to submit a plan to manage storage and dispose. That's going to be the BMPs.
I would concur with that. I don't think we want to have a bunch of additional plans. The question is we could either embed BMPs within the ordinance or embed BMPs within a separate resolution that the ordinance refers to that can be updated as technology and things change more easily.
I agree. And we could work with the industry to help us develop those BMPs.
Right.
Commissioner Curriasi.
Yeah, I think first, I just want to thank CDFW for bringing this is part of their role, is to bring up concerns and issues like this, and so I appreciate that. And I also think that the intent of the erosion control, at least my read of the intent of the erosion control condition, is to address historic or issues that have occurred in the past of poor management, poor disposal of this material, and it ends up, having these implications that we all agree is none of us want this. And the reason for the regulation is because there is a few that ruined it for the rest of us, right? There's why we have these kinds of regulations. I think, all that said, I completely agree. I'm not interested in punishing farmers that are using this correctly. It's a useful tool, and it's important for their work. And so if there's farmers that are managing it and using it and disposing it correctly, then I think I don't see a reason why we need to take that away from farmers. And I also really appreciate staff recognizing this inconsistency and bringing this to the commission. I think that's really important, and I think we're hearing that in public comment as well. And I think I'm leaning towards something like an ordinance. I really appreciate the argument around, or not the argument, but the pointing out the Pandora's box issue, and I also would like to avoid that. But going back to the whole intent is to try to address poor management and poor disposal. If we have something in an ordinance that gives staff the ability to go back to existing permit holders and go back to existing ministerial projects, and gives staff teeth to recognize if there is an issue a violation. If there's repeated violations, we can do that sort of progressive approach as we do with other sort of challenges. So I think I'm kind of leaning that direction.
I just want some clarification. I'm also leaning towards the ordinance as you spoke, but Director Ford, you mentioned that after the ordinance, it could be followed up with a resolution for the BMPs that could be updated over time. So I just want to clarify that you were also looking for the two pieces of work and how that would, if that was right.
If that's the approach the commission chose, yeah, and that's not unheard of. We've obviously done that. We did that with the watershed maps. We did that with the watershed limitations. The ordinance refers to the watersheds, and then those are adopted by resolution.
And is that somehow advantageous to just the ordinance on its own, right?
So the thing that you get to there is that you don't have to open Pandora's box to modify the BMPs.
Okay, thank you. Perfect.
Can you clarify again what you pointed out? I didn't quite follow. So if we're referring to a BMP, then we have to update that regularly? Is that the?
So the way you phrased your comment, and you were speaking just for support of the ordinance, which I agree with, but Director Ford had previously stated it would be an ordinance followed by a resolution, and the resolution would have the BMP specifically. So in time, if some great new material comes out, then we can just update the resolution and not go back to the ordinance, so we don't have to open Pandora's box, which addresses the other concerns.
Awesome, thank you. I also very much agree with Commissioner Scavdall, and I don't think we need to impose another plan as well, and I like that approach.
So I'm going to jump in and add, I have a little bit different perspective of the erosion control from my experience of going and cleaning up sites. Is a lot of times the wattle, it has that really fine monofilament netting, and then once the straw decays, it's easy for it to wash down into the water courses, and that's like from my experience where I found a lot of it, and that's where I believe, although I'm not CDFW, so I don't know where it all came from, but seeing hazards to fish and salmonoids, that's my experience. So I just wanted to add that in there. And then question for staff, and this way out on a limb, is it possible for the commission just to make a resolution that just authorizes the director to rescind that condition of approval on 500 and something projects?
I don't feel comfortable saying yes to that.
Okay. I appreciate the honesty. Commissioner West.
Just to quickly weigh in, I don't think I could say it any better than Commissioner Curriasi said it earlier. I agree with a lot of the sentiments expressed and in support of like best management practices. I agree that a plan is probably not necessary, and pursuing something that attempts to thread the needle between having something that's enforceable, that has teeth to help further protect wildlife, and also not drowning our cannabis farmers in more regulation is what I would hope for.
I just wanted to come back to your comment about the wattles, and I totally agree with that. If you use wattles with the monofilament around them, you're supposed to pick those back up, but often that doesn't happen. So better to use the wattles with the canvas or burlap wrap, which will decompose in place. And I think we're not really talking about that here. I mean, I thought we had consensus that we weren't going to be using netting as it related to erosion control practices.
That's State Water Board. I was trying to give a little bit of piggyback a history of where
Okay.
that needle might have,
Right.
somebody might have slipped in cultivation activities, and then all of a sudden it was a condition of approval, and they're like, hey, that worked. So that's kind of how the cannabis world has evolved here in Humboldt County. Sorry, that might have been too much, but
I mean, I think I would just say I felt like maybe there was sort of a general leaning or consensus towards the ordinance that would be followed by the resolution focused on BMPs. Is that?
Can I get clarity on what the ordinance, what would that look like? Or, I know, yeah, I just kind of spitballing.
At least I think in our mind, it would be a fairly simple addition to the ordinance that identifies the inclusion of BMPs, and that those BMPs would supersede conditions on the use of monofilament netting.
And would that give staff the ability to, if observing poor management practices in, they're not following the BMP, does that give staff the ability to sort of follow up in a progressive style?
Absolutely, because that then becomes a requirement of the ordinance, which is law. And so it doesn't need to be a condition at that point. It's implemented through the county code.
Commissioner West.
So tonight, you're not looking for a motion from us, you're just sort of taking our temperature, or do you need a motion?
They're looking for a motion.
Yeah, we would love to have a motion to be able to go forward to the board or start to take whatever next steps are appropriate.
Commissioner Scowdall.
I'll take an attempt at that. Modifying the wording of alternative 2, I propose to make a motion that we revise the land use ordinance to provide for the use of synthetic netting in cultivation activities, with said use following best management practices as attached in some other document or exhibit, where the use is allowed. And leave it at that.
In your motion, you're requesting authorization from the Board of Supervisors, correct?
Yes, and requesting the staff to develop those best management practices and bring them back to us.
Okay.
Before I offer a second, can I just clarify with Director Ford that the way it was proposed covers the ordinance and then the resolution sequence?
That's how I interpreted it.
Okay, then I'll second your motion.
I have
Commissioner
a
West.
question. So pointedly out of that language is missing the enforced mismanagement of synthetic netting. And I have concerns around developing something that is simply guidelines that is not enforceable. Can you elaborate a little?
I'm fine with that if you want to make that modification. I was reading through there and trying to drop out all of the planned stuff, so it didn't pick up on the enforcement.
Okay. Okay.
So, quick clarifying question. In our projects right now, there's a condition somewhere that states all refuse and trash will be stored in a animal-proof container, correct? Wouldn't monofilament netting stored on the ground that's cut up be considered misuse, or you're already not getting a you're already not checking off a qualification or a requirement of your project? In my mind, that's the way I look at it. One of these pieces.
Can we amend the amendment to just enforce non-compliance with BMPs?
I like that.
Rather than try to list all what non-enforcement entails. Can we just simplify it?
Because what I was trying to say is, I view, if you go on an inspection and you find a piece of this, even piece like that on the ground, that's not properly disposing of your refuse. So you're in violation, even if you don't have a monofilament. I mean, that's the way I look at it. So I think we already technically are covering that. Maybe it's just the way we're looking at how we enforce the rules that are already out there.
I think that's true, but that doesn't get to the heart of a struggle that we have. Is some permits, approximately half of them, are prohibited from using monofilament netting.
I don't disagree with that part. What I'm trying to say is, right now, if an inspector went somewhere and there's a piece of this on the ground, that's technically a violation.
Agreed. And just, if I could follow up on some of the questions around enforcement, once it becomes ordinance and once the BMPs are established, they will be enforced. I hope that's enough said on that. I mean, I can go into more detail, but when you have an ordinance, that is something we enforce. We have a checklist that we look at when we go out to inspect a site, and it's conditions and ordinance requirements, and both of those get reviewed.
Commissioner Curiosi?
I initially had a little bit of an issue with including language that says use of monofilament is allowed, in the sense of like trying to pare down language. However, am I correct in hearing that we need to include that in order to address this inconsistency?
Correct.
So we have a first and a second, correct?
I think an amendment to that.
And
Well, so my second would be with both amendments made.
and the motion maker was accepting of those amendments?
Yes.
Okay. Any other clarifying questions?
Can staff read back?
I was kind of wanting to
Okay.
go there so that way, because I'm kind of like, I don't know if I support this or not.
The way I understood it was it was a hybrid of alternative 2, which I'm madly trying to get to.
somebody try to restate it?
Sure, I think I've got it. So, as I understand it, it's a modification to alternative two to allow synthetic netting, requiring the use of BMPs. That would be embedded within the ordinance, but the BMPs would be allowed. Commissioner Scavdall in the motion said by separate instrument, but it's really by a separate resolution. And that the BMPs would be brought back to the commission with the ordinance for review and adoption at the same time. There was concern about the missing enforcement action, and that I know that's language out of the alternative, but we will capture the enforcement part of that within the resolution itself, identifying that there would be provisions to enforce the ordinance and the BMPs.
First and seconder agree that that is the motion that they are supporting? All commissioners clear with that? Okay. Call for a vote. We'll do a voice vote. All in favor, say aye.
Aye.
All those opposed? Motion carries. That was coin flip for me, but. Sorry. I think we're
done.
I kind of think we workshop and then we have just report from planner, and then can we go through that and then, okay, report from planner?
I don't have an update for you tonight.
Okay. Along the lines of report from planner? Okay.
Do you have any updates on whether or not you were, not about if you did a site visit, but we had a application before us at our last meeting where there was supposed to be a site visit the next day. Was staff able to visit the site the next day?
Yes, we did go out and visit the site the next day.
Excellent, thank you.
Okay.
Do you want to give an update on that?
Please don't elaborate till the hearing.
What's that?
The update is going to be that we will have that update presented to you at the next hearing.
Okay. Sorry, I just don't want to possibly provide, like, yeah. Any planning commission discussion items? Okay, meeting is adjourned at 9:17.